there are two applications, my lord, which are due to appear before your lordship together on 20th of this month for final hearing. One application is for rejection of plaint, another is my application for injunction. My lord, what I am submitting to your lordship is, my lord, for the convenience of the parties, my lord, let the rejection of plaint application filed by the defendant be taken up earlier than the injunction application, not on the same day, my lord, but on any day subject to your lordship's pleasure.
Why?
My lord, whenever the injunction application is being taken up, my lord, previously also, the defendant is coming with a defense that the suit is not maintainable, the plaint is liable to be rejected, and my lord, in that way, the hearing is deferred.
That's why both the application is fixed on 20th November.
20th, my lord.
Readings completed.
Everything is complete,
So
my
both the
lord.
matter be taken together. If the rejection is allowed, then automatically suit goes. If that
What I am submitting, my lord, if it can be 1 day or 2 days before the matter is taken up, my lord, first rejection application, then, my lord, the injunction application.
Okay, then let it come on time. But now what you want?
My lord, that I am asking for praying for fixing a date for.
So 20th it is fixed, no?
Yes, I am giving the notice.
Okay, 20th it is already
20th,
fixed.
both
So
are already fixed.
It
Both.
will be taken on that day. First, I will take the rejection of plaint.
Lodge.
No problem. If you submit, then I will take the rejection of plaint first.
Lodge.
May I have my lords kindly leave to mention, my lord, item number 144 of your lordship's, my lord, regular list, my lord. Here, my lord, clients have already settled the suit matter, my lord, dispute. Now he wants to withdraw the suit, my lord. I have received instructions from the client, my lord. I'm mentioning upon notice, my lord.
Commercial?
Non-commercial, my lord. This is the instruction received from, my lord, the client.
Yes.
Item number 144 of your lordship's combined list, my lord.
It is non-commercial?
Non-commercial.
It is written as commercial?
No, the number has come as that, my lord, but it's under the non-commercial list, my lord.
So let it tomorrow has to be mentioned.
Grateful, my lord.
My lord, may I mention, my lord, one non-commercial matter, my lord. Other side is also appearing. I am, my lord, for the plaintiff, my lord, matter is fixed on tomorrow, my lord, at my lord 2 p.m. for my lord cross-examination of our witness, my lord, plaintiff's witness, my lord.
You are witness.
My lord, my lord, our counsel, my lord, Mr. Kankani, he has some, my lord, medical exigency, my lord, in his family, my lord. That is why, my lord, he could not be prepared, my lord. If your lordship kindly adjourn the
Evidence is started, not is
Yes, yes, lordship. Yes, lordship. Evidence started. That is for cross-examination.
Cross. I am to do the cross.
Yes, lordship.
Cross-examination is going on.
Yes,
So what preparation is required? Cross-examination.
Lord, he could not be prepared.
Huh?
He could not be prepared, my lord.
Cross-examination, what you be prepared?
Saying that he could not sit with the
My lord, my lord, every question, my lord, if any question, my lord, has any difficulty.
Which year suit?
My lord, 2021. If your lordship kindly, my lord.
Okay, mention tomorrow, take note of it. It will be listed tomorrow, but I will adjourn, the matter will be adjourned.
Extremely good.
Lord, may I have a lordship's leave to mention a suit, 2024 suit, my lord, here, my lord, for listing as to be mentioned for passing procedural orders, for passing directions for discovery and inspection of documents. My lord, written statement and counterclaim has been filed, but thereafter nothing has happened. My lord, that is fine.
Counterclaim WS filed?
Yes, my lord, WS.
Written statement is filed?
Yes, my lord, filed along with the counterclaim.
A commercial matter?
Yes, my lord, commercial matter. My lord, I'm mentioning upon notice.
Who is for the other side?
But Mr. Shane was appearing, but my lord,
okay, inform other side.
I shall. I have given notice, but
on Monday, Friday.
Grateful, man. Grateful.
Inform the other side.
I shall, man. Grateful.
Well, this is the one, my lord. My lord was pleased to admit the plaint on the day previous to the vacation. It's in connection with, my lord, certain shares, my lord, which I was dealing in, and they were pledged, my lord, by the broker. Now, my lord, there is a requirement for interim relief, but I am told, my lord, in the meantime, there have been certain developments. So it would not be proper for me to to move this without bringing those on record. Would your lordship permit this matter to retain its position on Friday? I'll come up with a supplementary affidavit.
Friday, yes.
To retain its position, my lord. Obliged, your lordship.
As per so appearing for the plaintiff, as per the prayer made by the counsel for the plaintiff, the case adjourned, let the matter appear on 8th November. Under the same heading.
Obliged, your lordship.
Lord, in this matter, Section 8 application, my senior Mr. Chatterjee has commenced arguments. Your Lordship had given us leave to file a supplementary affidavit annexing certain documents which are there filed before the arbitrator. The supplementary affidavit was affirmed before the vacation, but it has been served yesterday. So let them file an affidavit. They would like to file. Your Lordship had given them an opportunity. My
Acha.
filing the supplementary affidavit is served
What has
yesterday.
happened? Award passed.
No, my lord, award has been reserved. It's been
Reserved.
reserved.
Not passed.
No, passed. We were hoping it will be
Very
passed in the
serious
meantime.
points are being argued. May I, my lord, file the affidavit, supplementary affidavit?
So and so appearing for the plaintiff. So and so appearing for the defendant number one.
Different number one.
Defendant number one. Counsel for the plaintiff has filed supplementary affidavit by serving the copy to the learned counsel for the defendants. Counsel for the defendant pays for time to file affidavit in opposition to the supplementary affidavit filed by the plaintiff. Let's affidavit to the supplementary affidavit in opposition to the supplementary affidavit filed within a
2
week.
weeks. 3 weeks. 3 weeks, man.
3 weeks.
Well, 2 weeks.
2 weeks, reply within a week thereafter. Please the matter on
Okay.
Affidavit filed.
6th of December.
Grateful.
6th of
December. 2 week, 1 week.
We have filed blood.
Yes,
Yes,
supplementary. They will file affidavit. Then you will file reply.
We are late.
Affirmed before
My
I
reply.
come to this, yes.
It's 6th December.
What no reserve that?
Supplementary affidavit filed by the plaintiff be kept with the record.
Grateful.
Grateful.
The plaintiff. We are to commence the repayment.
Yes, right, Mr. Mitro.
He's here.
Okay, passing it over. Passing. Or you will argue. Acha, yes, come. Yes, come. Yes, come. Yes.
Section 8 application. I'm not going into the merits of the case, but I must give a brief overview as to what the plaint case is for your lordship to know whether it's referable. The plaint case is twofold. It concerns the contract and the bank guarantee. According to as per the plaint case, post the contract, there was a government memorandum which applied to existing contracts of public sector undertakings. At the hearing of the injunction application, if this matter survives till then, I will try to show my lord that that has been judicially held by our High Court also, that office memorandum is binding on government companies as well. So that the office memorandum, which requires the government companies to reduce the bank guarantees received against performance security from 10% to 3%. So my first part of my case is that the guarantees which are given as performance security should be reduced from 10% to 3%. So my exposure, my risk gets reduced from rupees X crores to Y crores. That's the first part of my case. Second part of my case is that even this bank guarantee, as reduced, should not be invoked for reasons A, B, C. Their notice is bad. I mean, their threat is bad. Their termination is bad. So, my lord, one part of the case, that termination, that this claim for invocation or bank guarantee or the can give me 1 minute or the termination is bad, is covered by the arbitration agreement. But this first part of my case, that is reduction of the bank guarantee, is on the basis of an office memorandum of the government.
Why not the arbitrator cannot take into consideration?
I will just I will have to address your my lord why this government memorandum, whether it's binding or not, whether an arbitrator can decide.
because this is not arising out of contract, but on the basis of a constitutional doctrine that that the public sector undertaking should abide by government guidelines and not act contrary to it. That is the because these government guidelines have, even if not the statutory effect, but still by principles of Article 14 and the like are binding, and so the arbitrator would be bound by it. So that will bring me to the to answering my lord's query. That's why, in fact, I've come prepared to answer. This does the first answer is a simple answer. The contract itself says disputes arising out of the contract.
Correct.
Now, this is a post-contract office memorandum. Now, that's the simple answer. But then to be more, complete answer, I will have to show my lord that these office memorandums, government principles, whether they are applicable to the plaintiff, to one of the parties, public sector undertaking, or the state who's before the arbitrator, cannot be considered by an arbitrator because it has been judicially held repeatedly that these are in the public law domain. A government memorandum, office memorandum, binding nature of it, whether a public sector undertaking or a state is bound by an office memorandum.
Let the at the first stage arbitrator decide.
Well, that is beyond the, I will endeavor to show my lord, that is beyond the jurisdiction of the arbitrator. Beyond the jurisdiction, because that's in the public law domain, which the arbitrator has no jurisdiction to decide. Or she kindly comes, firstly, may I show the plaint first, where it arises out of the by cause of action arises out of the office memorandum. Substantial part. I would say 60-70% of the cause of action arises out of the office memorandum. Lord, you kindly takes a look at the plaint, which starts at page 28 of the Section 8 application. It is not my case, nor can it be my case, that the agreements was modified. That's not the plaint case, because the agreement can't be modified by third party. The agreement can be modified by bipartite. So it's not a case of an agreement being modified by a third party. Government can't be. Now, Lordship kindly comes to my plaint. Internal page 4, Lordship, that is running page, paragraph 10, running page 31. Paragraph 10. It is in this factual background, because previous paragraph is the contract and whatever, COVID-19. It is in this factual background that the Procurement Policy Division, Department of Expenditure, Ministry of Finance, Government of India, issued an office memorandum date 12 November 2020, bearing number so and so, whereby the Government of India directed the reduction of performance security from existing 5 to 10% to 3%. Of the value of contract for all existing contracts. The said direction was applicable to any kind of procurements, including goods, consultancy works, non-consultancy services, and such orders. A copy of the office memorandum is annexed as Annexure B. The said office memorandum, on the face of it, records a government policy which is binding on the defendant. Because this is not modification, but a government policy. Yes. The Secretary, Department of Public Expenditure, in writing, has directed the defendant number 2 to follow the said office memorandum.
Yes.
The defendant number 2, being a public sector undertaking, is bound by the directions of the central government. Then paragraph 11, pursuant to the said office memorandum and directions of the government, the plaintiff issued several emails and letters to the defendant number 2, seeking amendment in the contract for reduction of the performance bank guarantee amount from 10% to 3% of the value of the contract. The defendant number 1, however, did not pay any heed to the requests of the plaintiff.
Yes.
I'll come straight away to paragraph 13. The last 6 lines of paragraph 13, internal page 6 of the plaint. The last 6-7 lines, the last sentence.
Yes.
The defendant number 2 failed and or neglected to take any steps to reduce the performance bank guarantee value despite the aforesaid mandatory direction of the government. and the plaintiff's numerous requests in this regard. This then takes me to paragraph 15. Paragraph 15, the said 3 rakes could not be delivered within the originally stipulated delivery period of 16th October on account of factors and reasons beyond the control of the plaintiff. The particulars of such reasons and factors contributing to the delay in supply of the rakes under the purchase order are stated here and below. B. Delay in clarification by defendant number 2 for value of PBGs to be furnished by the defendant in terms of the office memorandum dated so and so, issued by the Procurement Policy Division, Department of Expenditure, Government of India, pursuant to the outbreak of COVID, by which the value of the PBG to be furnished to PSUs was reduced from 10 to 3%. Then kindly turn the page to subparagraph E. Non-release of 7% order value of PBGs pursuant to the office memorandum dated 12 November 2020, the plaintiff was entitled to obtain release of the performance bank guarantee furnished by it, equivalent to 7% of the order value under the purchase order. The defendant number 2 failed and or neglected to release such PBG despite directions of the government in that regard, and numerous requests and reminders being issued by the plaintiff. The retention of PBGs within the 10% order value has caused liquidity shortage and financial stringency, which had in turn adversely affected the plaintiff's capability of manufacture. Now, Lordship kindly comes to paragraph 19, internal page 11. In view of the said amendment at the cost as a repetition, it is stated that despite resolving the issues in respect of extension of delivery period, the defendant number 2, however, failed and or neglected to address or resolve the following subsisting issues in respect of the purchase order, without which there was no valid extension. A. Despite repeated requests of the plaintiff and the mandatory direction issued by the government by way of the said office memorandum of 12 November 2020, the defendant number 2 failed and or neglected to release the PBG having 7% order value.
When the contract was entered?
The contract was entered on 23rd October 2022, no? 2020. And this is 12th November 2020.
After that?
After that.
So
May I just show the
whether retrospective effect or
yes. That is the which page is it? 86. Page 86. Page 86. Lordship, kindly come to page 80. 86 of the section 8 application. Section page 86 of the section 8 application. Page 88. Page 88. Kindly come to paragraph 3.
Page 88.
Yes, page 88. 12th November 2020.
Yes.
Lordship, kindly come to paragraph 3. In view of all above, it is decided to reduce performance security to 10% to 3% to 3%. Now, kindly see paragraph 4. Further, all tenders, contracts issued, concluded till 31st December 2021 should also have the reduced performance security. Now, paragraph 5. In all contracts where performance security has been reduced to 3% in view of the above stipulation, the reduced percentage shall continue for the entire duration of the contract, and there should be no subsequent increase of performance security beyond 31st December 2021. Wherever there is, yes. So, Lordship kindly sees, further, all contracts concluded till 31st of December shall also have the provision of reduced performance security. And Lordship, paragraph 3 is my mistake. Paragraph 3, I should have placed more detail. In view of all above, it is decided to reduce, kindly see paragraph 3, to reduce performance security from existing 5 to 10% to 3% of the value of the contract for all existing contracts. For all existing contracts. However, the benefit will not be given in the contracts and the dispute where in arbitration have been already started. So existing contracts exception is where legal proceedings have started for all existing contracts. Paragraph 3.
So if you are relying upon this, you can rely before the arbitrator also.
That is the question. Now I shall come to Lordship. On this basis, my prayer, Lordship, also has seen is there are several pleadings in that regard, various pleadings, and my first prayer is that my prayer C is based on that. In fact, prayer C is the basis. My first prayer.
In the suit.
In the suit. That's the internal page 19 and page 46 of section 8 or internal page 19 of the plaint.
Yes.
My prayer C, mandatory injunction directing the bank to immediately do the following. Treat the bank guarantee numbers so and so respectively as void and ineffective, and alternative to treat the aggregate value of the two bank guarantees as 1 crore 28 instead of 4 crore. So that's reducing from 10 to 3%, and Roman 2 is not the same, is the same line, reducing it from 10% to 3%. And consequently, my prayer C will also be impacted.
Yes.
So this is my cause of action, this is my prayer. Now, Lordship, whether this office memorandum does not amend the contract, but this is a government circular binding on public sector undertakings, and they would be duty bound to act in terms. Lordship, a similar issue came up recently in port trust contract. Port trust contract was there for certain rate. Then, under the Major Port Trust Act, Lordship knows the tariff authority determines the rate. The arbitrator had that issue before him, whether the rates were to be reduced or not, or whether the rates should be applicable as per the schedule of rates of tariff authority. And arbitrator's award was based on that. That subsequently, there's a schedule of rates, and that should also be applicable in this case. An award was made. The award was set aside only on the ground that an arbitrator is the product. Arbitration is the product of a contract. Any other statutory, non-statutory actions of the state, even if by applying Article 14 of the Constitution, will not be relevant before the arbitrator.
Yes.
The award was set aside, and I will show the recent judgment, and also I'll take your Lordship backwards to the Supreme Court and all the other judgments and other different courts, which said the arbitrator cannot look beyond the contract. And any other issue arising even under a statute which has an impact, or as in here public law domain, that being a statutory authority or bound by the office memorandum, that's in the public law domain. If they say that they'll be bound by it, and the rest of it is a different matter. But if they don't, arbitrator can't decide these issues, Lordship. May I straight away come to the first judgment on this proposition. Let's start with the universal. Let's start with universal. Lordship kindly takes the judgment, the latest judgment. May I go backwards? You kindly takes a look at Justice Sarab's judgment. In universal. At 20. Yes, universal. Paragraph 26, na? Yes. Paragraph. No, you're given the SCC copy. Oh, all right. Fine. Then Your Lordship kindly comes to paragraph 28. I'm reading or you just follow it. Paragraph 28. In my understanding, in my understanding.
Yes.
The respondent seems to be, in my understanding, the respondent seems to have had found favor with the arbitrator's sympathies, but unfortunately, they do not find favor with my sympathies. And most unfortunately, they did not find favor with the law. Saab's typical style, it is evident that that considerations of discrimination and want of state functionaries to act in due conformance to Article 14 of the Constitution swayed the arbitrator's contractual interpretation. The aforesaid inference can be gauged from paragraph 5E of the judgment. Firstly, the arbitrators cannot apply the rights envisaged under the fundamental rights of the Constitution or equity while granting arbitral awards. And if they do so, such awards must be set aside, granting arbitral award. And if such award is set aside as being patently illegal under 34(2)(a) of the Act. The arbitrator is a creature of contract and must act within the powers granted by it. In Board of Cricket Control versus Deccan Cricket, that's a Bombay High Court, this is Patel's judgment. The Bombay High Court, while dealing with the arbitrator's power to invoke Article 14 of the Constitution, held paragraph 215. Two different considerations arise when one of the parties is the state within the meaning of Article 12. Here, the learned sole arbitrator held that BCCI is not the state, but held that it nonetheless performs public functions. Would that make a difference in arbitration? A dispute resolution constrained by private law? It would appear not. Certainly, the public law duty to act fairly cannot be imported into a contract by a private law arbitral tribunal to effectively alter its terms so as to create an obligation on the so-called public duty party that the contract does not envisage. Assistant Excise Commissioner versus Isaac Peter. This is true even of a statutory contract. In Isaac Peter, the Supreme Court held that in case of contracts freely entered into with the state, there is no room to invoke the public law doctrines of fairness and reasonableness to alter or add the terms of the contract to cast, that is to cast from the state a contractual burden. Contract itself does not contemplate. A division bench of Delhi High Court went so far to say that there is no scope of applying doctrine of arbitrariness in the private law field. That remedy is a public law remedy. A division. Now, logically, come to paragraph 217. There can be no answer at all to Mr. Mehta's submission that there is no quarrel with the proposition that a court, even especially a constitutional court, is not constrained in the same way as an arbitrator. I am on that. A court is not constrained. Public law actions demand public law remedies. The suggestion is not that a public authority can play Jekyll and Hyde, or that it is required to demonstrate fairness only in a public law action. The question is, what is it that the decision-making body is empowered in law to do? A writ court may well hold against a public body on a public law principle or by invoking Article 14. But an arbitrator, constrained as he or she is by the contract, has no such power. A careful reading of the relevant authorities, Sileka Vidyarthi, shows that courts have indeed demanded Article 14 compliance in exercise of questionable public law judicial powers. I find absolutely no authority for the proposition that a private law bound tribunal has recourse to such power. I find myself in complete consonance to the above view. However, Mr. Rotnanko Banerjee, senior advocate, attempted to impress upon me that the arbitrator might have alluded to Article 14 of the Constitution aspect of discrimination, but the award was actually based on Section 28(3). Because the 28(3), Lordship kindly sees here paragraph 29 and 30.
Yes.
That is, the logic flows from paragraph 29. Yes, sorry, paragraph 32. Paragraph 32. in SCC printout. Therefore, the said assertion that the amended section 28(3) somehow vindicates the conduct of the arbitrator in passing the said award cannot be countenanced. In fact, in certain exceptional situations where an unilateral addition or alteration of contract is done by a party is forced to perform a bargain not entered into with the other party, courts can also set it aside for being against the most basic notions of justice as being a ground under 34(2). As explained 76 by Sang Yong. Section 28(3) lays down that an arbitral tribunal should take into account the terms of the contract and the trade usages applicable to the transaction. However, in my understanding, from a reading of the law discussed above and the section itself, terms of the contract and trade usage are to be considered conjunctive. Law may assist in the understanding of the former in situations wherein the former is ambiguous or completely silent. But at the cost of repetition, explicit understanding of the parties as examined that too, when which have bearing on the fundamental issues of dispute cannot be ousted in favor of consideration of trade risk. Now, Lordship, I don't think I need to trouble. The award was set aside. Lordship, kindly come to the 37 में क्या है the above paragraph. Paragraph for 41, the last 7-8, paragraph 41. Paragraph 41, just above the quotation, 5-6 lines above the quotation. Secondly, has what you found? Secondly, the applicability. Secondly, paragraph 41. Secondly, applicability of stamp rates based on the Port Trust Act will anyway be ousted if it is outside the scope of the contract. This court states the single authority will decide the applicability of the amendment, even though it is not provided. So, well, these methods, the award was set aside on this ground, on the for applying public law doctrine, and
I think this Steel Authority of India, Vizag, this is my judgment.
judgment.
Yes.
Now, Lordship, may I come to one paragraph, though it's been quoted extensively by Justice Saraf in this judgment. The penultimate judgment is Deccan Chronicles
Deccan
case.
Chronicle, yes.
But you kindly see just, I will not repeat what Justice Saraf has already quoted, but just 2 paragraphs from here. This is same as what I gave you. Yes. Okay. Or she kindly comes to paragraph 215. Paragraph 215. This is a very interesting distinction. Section 9 court can apply that, but not the arbitrator. But you kindly see paragraph 215.
Yeah.
I find Mr. Jagtiani's reliance on the decision of the Delhi High Court in KSL and Industries versus National Textile Corporation to be entirely inapposite. The court had before it 3 Section 9 petitions. A Section 9 court's powers are not constrained by Section 28. The arbitral tribunal is so constrained. Section 9 specifically uses the word just and convenient. A possible jurisprudential or statutory riff on the ex aequo et bono principle. The learned single judge from paragraph 89 took the view the fight between the citizen and the government is not to be viewed as an ordinary litigation. BCCI is not the government. The entire discussion that followed in KSL industry was about what courts had done in one proceeding or the other, the form of that action being immaterial. But this cannot and does not mean that the same principle can be extrapolated to the narrowly tailored confines of an arbitral tribunal, an adjudicatory body of a very special stripe, one not brought into being by the constitution or law, but only by a binding contract between the parties, and constrained by the terms of that contract. If this view is to be imported into arbitration, we face a fundamental problem. No arbitrator is any longer a creature or creation of contract. He is an alternative curial authority, not a private alternate dispute resolution entity. An arbitrator's canvas is rigidly limited by the parties' agreement. A court's canvas is not. This and paragraph 217 only.
Yes.
There can be no answer at all to Mr. Mehta's submission. There is no quarrel with the proposition that a court, especially a constitutional court, is not constrained in the same way as an arbitrator. Public law functions, actions demand public law remedies. The suggestion is not that a public authority can play Jekyll and Hyde, or that it is required to demonstrate fairness only in a public law action. The question is, what is it that the decision-making body is empowered in law to do? A writ court may well hold against a public body on a public law principle or by invoking Article 14. What a writ court can do, a suit court can also do. Anyway, that's not been argued by them. But an arbitrator constrained as he or she is by the contract has no such power. A careful reading of the relevant authorities, like a Vidyarthi, so and so, shows that courts have indeed demanded Article 14 compliances, fairness, and non-arbitrariness in exercise of unquestionable public law judicial power. I find absolutely no authority for that proposition. The private law bound tribunal has recourse to such power. Well, I am on that. Well, this is on, well, your lordship's court can. But the public law, this I shall take it backwards. Now, I will go to the earlier judgments, couple of earlier judgments. Lordship, this is, and then I will, and the rest of it will just fall in place. In fact, I will show that the judgment cited by them for the principle that you can't bifurcate. You can't say arbitrator will decide this part and the court will decide this.
It cannot be segregated.
Cannot be segregated. So and this is not a contrived case. That's not their case. That this is not a contrived. I've joined in this just to house the court's jurisdiction. This is my cause of action. Without 2000 calculator, 2000 calculator. Even before this is post 1996 Act. Even before this was a law even earlier. Or she kindly takes even before 28(3) was brought in specifically by statute. This was a law even earlier. Yeah, this is of course the post 1996 judgment. I will show one pre-96 judgment also. This is reported in All India Reporter 2000 Calcutta 232. Kindly come to paragraph 90. Paragraph 90. Having heard the learned counsel for the parties and considering the materials produced before me, it appears to me that there's a question as to whether the 91 one is whether the petition should be entertained in this case. Firstly, in view of the existence of the arbitration clause. It appears that Justice S.V. Sinha in his judgment reported 95 Calcutta has been pleased to observe that when there exists an arbitration clause, the writ petition normally does not lie. It appears from the language of the said judgment that the opposite principle is not inflexible. In fact, his lordship has not, of course, propounded such absolute and inflexible theory that the existence of the arbitration agreement will stand in the way of exercise of writ jurisdiction. Ordinarily, such course of action is not entertained by the court. In my view, the existence of the arbitration agreement is nothing more than existence of an alternative remedy, and it does not stand in a different and separate footing also. It is settled when the question of unequal treatment and further complaint of arbitrary unfairness and malafide state action has been raised. Such question can only be effectively decided by court under Article 30. In the said decision, it appears that one of the parties had resorted to mechanism of arbitration agreement by filing an application on 20. So factually, the aforesaid case was also distinguished. In this case, I am of the view, going by the averments of the petition and the submission, Mr. Roy, that the petitioner questioned the act and action of the respondent number 2 in refusing to grant extension up to 500 episodes, and by not allowing the petitioner to telecast up to 500 episodes in conformity with the alleged agreement as being arbitrary and malified. The question, legitimate expectation in this case has been stated, but based on practice and custom. The question of frustrating a legitimate expectation cannot be decided by arbitration. The question absolutely remains within public law field. I have examined the arbitration agreement. It pertains to disputes relating to the written contract. In this case, the petitioner canvasses the dispute as stated here and above. Therefore, I hold a writ petition is entertainable and maintainable when the arbitration agreement is no bar. An earlier judgment, Lordship, in setting aside of an award case of Indian Oil Corporation in 1991 SCC, page 533. Paragraph 11. We may at the outset, this is 34 setting aside. We may at the outset mention that it is not necessary in the present case to go into the constitutional limitations of Article 14, to which the appellant corporation as an instrumentality of the state would be subject, particularly in view of the recent decisions in Dwakadas Marfatias, Mahavir Auto, and so on. This is on account of the fact that the suit was based only on breach of contract and remedies flowing therefrom. And it is on this basis alone that the arbitrator has given his award. Sri Salve is therefore right in contending that the further questions of public law based on Article 14 of the Constitution do not arise for decision in the present case, and the matter must be decided strictly in the realm of private law, governed by the general law relating to contracts with reference to provisions of specific effect, providing for non-enforceability of certain types of contract. It is therefore in this background. If my suit was based entirely on the contract, I would have been hit by the arbitration clause. Now, Lordship, kindly seize the arbitration agreement once before I proceed further. Page 64 of the Section 8 application. Clause 23, page 64. Matters in question, claims, dispute, and or difference in respect of the contract. It is a contract to be submitted to arbitration. This is a contract. So, if Lordship, as the Lordship knows very well, a court can't vest an authority with jurisdiction. Authority with jurisdiction can be only by statute. Now, Lordship, this will take me to the next part of my argument, which really flows from the judgment cited by the other side, 2015, 14 SCC, 444. Which is the law? 1514 SCC.
Sundaram Finance.
1514 SCC, 444 cited by
Sundaram Finance.
Yes, paragraph 11 of that judgment. Give me one copy. Other side has it. Tell your flag ticket. Where is my flag ticket? 1514 SCC paragraph 11. This is the law. And that lordship also, no one is joining issue. The attempt of the trial court and the approach made by the High Court in bifurcating the cause of action is fallacious. It will only lead to delaying and complicating the process. The said issue is also no more res integra. In Sukanya holding that paragraph 60, that was the section 8 case. It was held as follows. The next question which requires consideration is, even if there is no provision for partly referring the parties to arbitration, whether such a course is possible under section 8 of that. In our view, it would be difficult to give an interpretation to section 8 under which bifurcation of the cause of action, that is to say the subject matter of the suit, or in some cases bifurcation of the suit between parties who are parties to the arbitration agreement and others is possible. This would be laying down a totally new procedure not contemplated under the Act. If bifurcation of the subject matter of a suit is contemplated, the legislature would have used appropriate language to permit such a course. Since there is no such indication in the language, it follows that bifurcation of the subject matter of an action brought before judicial authority is not allowed. Secondly, such bifurcation of suit in two parts, one to be decided by the arbitral tribunal and the other to be decided by the civil court, would inevitably delay the proceeding. The whole purpose of speedy disposal of dispute and decreasing the cost of litigation would be frustrated by such procedure. It would also increase the cost of litigation, harassment of parties, and its possibility of contracting. Lordship, here this will take me to, before I cite any judgment, Lordship also sees the presence of the bank is not just to out the course jurisdiction. Here I have to claim reliefs because against the bank, because I'm asking for that bank guarantee to replace by another bank guarantee. The presence of the bank, the mere invocation case, I can stop my defendant from invoking the bank guarantee. But here it is more than that. On the basis of the office memorandum, I am saying that even the bank, this being a public law domain, this being applicable to a company like SAIL, Steel Authority of India, the bank should also act upon it and feed and replace the bank guarantee of whatever 4 odd crores to 1 crore. So that's why my prayer is specifically against defend number 1.
Simple case is that if they will take into consideration of the memorandum, automatically your PBG will come down. So whatever the
once it comes down, then of course it's in the private law domain.
Automatically it will come down. Thereafter, whatever your claim, then it will be considered.
So that is on the basis of that is the principle 1514 SCC, and also Lordship, there are several other, even 910 SCC. Lordship kindly sees the other judgment cited by them, 2009, that I think 910 SCC is the one which is in the, it is that magma. Yeah. Yes, Lordship kindly takes that that branch manager, Magma Leasing, cited by them, Magma Leasing versus Potluri Madhavilata. This is the same principle that you can't. Lordship has given a copy of that Madhavil.
Yes,
I think they had given AIR maybe 2010. Actually, copy to branch manager.
The copy was not given, you mentioned.
Oh. Paragraph 16. Paragraph 17, sorry. Page 114. Section 8 reads that. The section is quoted after that, after Placeter B. An analysis of section 8 would show that for its applicability, the following conditions must be satisfied. I am on C. That the subject matter of the suit is same as the subject matter of the arbitration. It's not the same. It's not arising out. So, not the same. To the same effect, I will show two judgments. The subject matter has to be the same. Each call. 2005-1 CHN. 5-1 CHN. 5-1 CHN 158. Paragraph 12. It was also a Section 8 case. Paragraph 12. The Supreme Court in P. Anand Gajapati Raju laid down the following conditions which were required to be satisfied under subsections 1 and 2 of Section 8 before the judicial authority can refer the parties to arbitration. Lorships 3. Subject matter of the action is the same as the subject matter of the arbitration agreement.
Similar.
Yes, is the same.
Correct.
Now, Lordship, can you see how the court has considered in paragraph 14 this principle? Because the subject matter was something else also, added this plus this. Paragraph 14. Supreme Court in Sukanya Holdings, which was the one relied upon 1514 SCC, held that the said Act of 96 did not oust the jurisdiction of the civil court to decide the dispute in a case where parties to the arbitration agreement did not take appropriate steps as contemplated under subsections 1 and 2 of Section 8. There was no provision in the Act that when the subject matter of the suit included subject matter of arbitration agreement as well as other disputes, the matter was to be referred to arbitration. There was also no provision for splitting the cause of the parties and referring the subject matter of the suit to arbitration. There was no provision as to what was required to be done in a case where some parties of the suit were not parties to the arbitration agreement. It has been held that the subject matter of the suit ought not to be bifurcated. Any bifurcation of the subject matter of the suit, one to be decided by the arbitral tribunal and other to be decided by the court, would lead to anomalous results. The Supreme Court noticed that this would inevitably lead to delay and increase again the possibility of 2-4 passing.
Yeah.
This and then there are several other judgments. I'm going to just for the sake of formality, Lordship, an unreported judgment in Good Earth. Page 19 of this judgment, a Section 8 Act was being opened. Page 19.
Yes.
Paragraph, page 19, the 5th line. This court thus has before it two separate claims made by the plaintiff, in which one includes part of it for total failure of consideration on allegation that it relates to breach by defendant to transfer the money, and at least acknowledgement of defendant that disputes are in parts for entirety of the claim to be deferred. Section 8 had its unamended provision substituted by amendment made and given retrospective effect from 23rd October 15. Between unamended provision and substituted provision by amendment, there is no change in the section to the extent a judicial authority for which an action is brought in a matter which is a matter of arbitration of a agreement challenge. Court finds subject matter of the suit cannot be said to be subject matter of arbitration. Arbitration agreement is contained in agreement 22nd May 19. Neither party has asserted arbitration agreement, oral agreement, treated in paragraph. Defendant's assertion that the entire dispute be referred to arbitration as arising out of agreement is to ensure the court is unable to accept for reasons of success. Then, Lordship, Amit Lalchand Shah's Sukanya Holdings, I am not troubling my lord. Lordship kindly comes to paragraph to page 21. Page 20. Page 21 at the very top. The first line. Page 21. Between parties herein, part of the subject matter of suit is not covered by the arbitration. Hence, court will not refer to that.
Yes.
So this is really the sum and substance of my submission. That part of the cause of action. I am not going further on allegations of fraud. How far? Because I think this is a case which is squarely covered by.
Yes, sir. Yes. Mr. Gupta.
May I give my reply next Friday?
Friday.
Lordship, not this Friday, I may not be
Friday
here.
থাকবে না
মঙ্গলবার, সোমবার তো হচ্ছে না।
মঙ্গলবার
Tuesday?
12 তারিখ না তো 12 তারিখ আমি থাকছি না
11 আমরা নেই, তো 12
ও 12 না 12 আমি করবো না।
Lordship,
12টা বাদ দিয়ে কর
Lordship,
12 না
next Tuesday or Wednesday, whichever.
Tuesday না 12টা
বলুন,
বাদ
আপনি
দিয়ে
বলুন।
other than 12th
It can be even this coming Thursday we are here. I'm not here on Friday.
11.
11, Mala, both of us will not be here, Mr. Gupta and myself.
Then 15 is holiday. 11, 12 and 15. 15 is holiday.
15th is all right
ছুটি আছে।
Holiday.
oh 15th is holiday
Holiday. Then 18.
18th is a Monday
Monday.
Yes.
So and so appearing for the plaintiff. So and so appearing for the defendant. So counsel for the plaintiff has concluded his argument by giving reply to the submission made by the counsel for the defendant in connection with an application under section 8 of the Arbitration Act. So counsel for the defendant prays for time to give reply to the judgment relied by the defendant and relied by the plaintiff in connection with GA 2 of 22. Concerning the submission made by the counsel for the respective parties, this is the matter on 18th November under the same heading has parted.
your AIR 2010 the corresponding citation that judgment has copy has been had
Lordship, there are two applications. The first is an application in the nature of a judgment upon admission. And the second one, your Lordship recalls, we troubled your Lordship right before the vacations with this application pertaining to, my Lord, restoration of possession of the plaintiff.
That one.
Yes, my Lord. The pleadings are complete. May I proceed with the second application first?
GA number 5.
GA5, my Lord.
What is the GA5?
GA5 is the application for restoration of possession of the plaintiff back into the subject premises where, my Lord, the Honorable Court, while passing the ad interim order in the year 2021, records that I am in possession and, my Lord, restrains them from creating any third-party rights over the subject premises.
Correct.
The claim arises out of a transaction where initially, my Lord, I'll give a brief background. Initially, my Lord, this property was to be handed over to us for the purpose of a lease executed between the parties. 5 back-to-back lease agreements for 5 continuous terms.
Between?
Between, my Lord, the plaintiff and the defendants. Midway after, my Lord, we were put into, they had to carry out certain works on the subject premises for the purpose of making the premises usable, which they failed to do. We expended sums to make the premises usable and we were put into possession by the defendants. Now, my Lord, midway what happens is we receive a notice from West Bengal Financial Corporation for the purpose of repossession because the premises was mortgaged to West Bengal Financial Corporation. Parties agree that we are going to take over, as in the plaintiff, instead of the lease, the parties agreed to the novation of the transaction and the defendants would convey the premises to the plaintiff for a consideration. Based on that representation, my Lord, we pay off the West Bengal Financial Corporation's dues directly. Apart from that, we also, my Lord, make an advance to the defendants to the extent of around 90 odd lakhs. We were continued to remain in possession and from there then, my Lord, we received the agreement for sale, which is evident from the exchange of messages over WhatsApp. It is very clear that they have sent us the agreement for sale and we wanted to execute it. They dilly-dallied and they did not execute. It is at this stage, my Lord, we asked very well, if you're not willing to execute the agreement for sale, then you should refund the sums of money. They did not refund. There, it is at this stage we come to court with a judgment upon admission application, where, my lord, the initial order of, my lord, April 2021 was passed. The order records, if your lordship takes up the order of April 2021, I'm led by Mr. Rex. The order, which is part of GA5,
27th April.
yes, my lord.
Page 25.
Yes, my lord. The order specifically records, my lord, that the plaintiff is in possession.
Yes, last paragraph.
Yes, my lord.
Page 25.
Yes,
last
my lord.
paragraph.
And, my lord, it also records that they will not create any third-party rights over the subject premises. Previously, what happened, they tried to dispossess us last year. There are police complaints to that effect. That is already on record. This year, sometime around, my lord, October, in fact, September, I'm mistaken, they dispossess us by use of brute force. My men and agents were driven out. All my equipment, my trucks, my vehicles are still inside the premises. My records are in the site office there. And, my lord, they prevented my men and agent from entering the premises. We approached the police authorities. The police authorities did not act at all. We lodged a complaint on the very same day when the incident took place. Dilly-dallied, didn't do anything. Thereafter, at night around 1 o'clock, the police registers a FIR complaint. Lordship, we approach your lordships then, upon our submissions, calls for a report from the police authorities. Lordship recalls on the day when the application was returnable and the police authorities had come with the report, my learned friends made a submission that no, we have not dispossessed. What has happened is there are labor disputes and the place was abandoned. Since it was abandoned, so we took possession. It is at this juncture, my lord, lordship directed exchange of affidavits. And, my lord, the matter was kept after vacation. And may I?
Eh, Manotosh. Anyone met one much more?
And with your lordship's leave, my lord. The question here today is, my lord, after we get their affidavits, it is an admitted position that they have entered into the possession on 13th of September. There is no dispute about that. From the affidavits, their affidavits only. So the question, my lord, today is, can I get the relief which I am seeking from your lordship, which is in the nature of a status quo ante, or mandatory injunction that they must immediately hand over the possession? Now, my lord, the question of mandatory injunction is a high, my lord, yes. But what is the basis of that? The basis is that where there is injustice in a pending proceeding, then your lordships have said that yes, we should pass orders of status quo ante. Now, my application is very straightforward, that I have been dispossessed, police is not taking steps. Now, kindly takes their affidavit in opposition, my lord. But will kindly take the opposition. The primary ground which they are saying is that we are lessees, we were lessees in the property and we have not paid rent. But this part has been already covered by the first order of this court, my lord, where the court said that this needs to be adjudicated, but the court says that you are in possession. Admittedly, I'm in possession, that was there. And on that basis, my lord, the interim order was passed, that no further rights
to be created. So, my lord, when this order was passed, there was a platform for passing this order that I was in possession. So it is not something that this court did not notice or did not take into contention while passing that order. Now, when they filed this opposition, my lord, but kindly takes the opposition. First things first, very interesting, my lord, kindly takes paragraph 6 onwards. Kindly see 6. Though termed as a lease agreement, as the agreement dated 1st October 2020 executed by and between the respondent number 1 and the petition number 1 was unregistered, and as the terms of such agreement, and as such agreement was for a period of 11 months only, the petitioner number 1 is inducted into possession of the suit premises a monthly tenant of the respondent. The period was from 1st October 2020 to 31st October 2021. Then, my lord, thereafter, 4 successive unregistered lease agreements or tenancy agreements entered into and executed by and between the respondent number 1 and the petitioner granting a tenancy in respect of the premises for successive terms of 11 months. Now, kindly see the period. The period is from 1st June 2024 till 30th of April 2025. Therefore, according to them, there is also a subsisting lease agreement. Thereafter, respondent number 1 and petitioner number 1 also execute an unregistered lease tenancy agreement for the future term of 5 months to commence from 1st May 2025 up to 30th of September 2025. So my tenancy rights are admitted by them.
Yes.
Now the agreements are annexed, my lord. Now, the agreements are all annexed, my lord. Then your lordship kindly comes to paragraph 16.
So this all with regard to the same property?
Same property.
Because the agreement is up till 30th April 2025.
My lord.
How again, without completion of the agreement again on 1st May 2020, or in the agreement itself it is mentioned about the date?
Back to back, separate agreements. It extends. 11 months and the last one extends till September 2025.
Correct.
Very interesting, my lord. Kindly see paragraph 16, my lord. I don't know how this has happened, but whatever it is. The respondent number 1 states that the petitioner owner has not paid a single sum on account of the rent to the respondent number 1 in terms of the said agreement. When they mention this said agreement, my lord, your lordship will kindly have note, my lord, that they are talking about the first agreement.
Initial agreement.
Of 2020.
Correct.
And a detailed chart of the amounts given by the petitioner to the respondent number 1 and the sum due and payable by the petitioner to the respondent number 1 has been calculated up to August 2024. And as on date, rupees 11,98,450 is due and payable by the petitioner to the respondent number 1. But there were no bills. They have not annexed anything. And very interesting, my lord, if that 2020 was not paid, how was the extensions being made?
That's why when this extension, the 5 agreements were entered into, as per paragraph 7, thereafter 4 successive.
Yes, my lord.
Thereafter which date?
One of the dates are, my lord, agreements. But I'll just give you lordship the dates.
Because the first is the 1st October.
That's 2020 October.
Next is 1st September 21.
1st September 21 is the next one.
1st August 20.
So that is after the order.
Yes.
After
But it's in my GA1. They're all there. All annexed.
Okay.
And they have also, as a matter of fact, annexed in Annexure D to H of this affidavit.
Yes. Next.
Now, my lord. So the case which my learned friend is running, my lord, good, bad, indifferent, that there is dues. There are dues. Now, my lord, I had filed this suit because I had paid them 46 lakhs. 70 lakhs, sorry, my lord. They admit that amount. My lord, that has not been paid to me. So, my lord, today, my lord, even if they set off, this amount was due and payable to me. Now, as that condition, my lord, and since I was in possession, interim orders were passed by this honorable court saying that no, you cannot further create rights on that property. Now, the case which they are running now, my lord, as an overall case, my lord, is that a lessor or a landlord is taking away possession without my surrendering, without my concession, and I say by brute force. If they say not by brute force, I can at least say that it is not in accordance with law. So the ultimate case is that I have been dispossessed but in accordance with law in a pending proceeding where this property was being secured in whatever way this court felt proper. Now, my lord kindly sees what is the case they are making now.
Para 30.
No, para 13, my lord, is, my lord, again their original case now. I am talking about the disposition part now. But in there, they are saying that I had given them the money, there's no dispute. After that, they're saying that we had not entered into a contract with them with regard to the conveyance part. So that will be subject matter of the suit when it will be decided. But what have they done in the meantime is, my lord?
Suit for specific for
Money claim.
money.
Money claim, and that is now as a security. The property. And that is what was given, because I had said a judgment of an admission, to which the court allowed my prayer, saying yes, therefore that is injuncted. So while it is injuncted, my lord, now I am thrown out, where the court took into contention that yes, I am in possession, or else I would have got better orders.
So what is the money claim? How
My lord, money claim is 70 crores, 70 lakhs.
for what?
My lord, yes, my lord. My lord, this property was mortgaged by them to, you know, West Bengal Financial Corporation.
Okay, you are deposited.
I had given them saying that I will take it up and I will buy the property. Then I was put in possession on a lease. They did not pay WBFC. And they did not pay us also.
Sale agreement. This is from their end to us.
My lord, in the main application, we have also shown that there was this agreement which was being discussed and negotiated. My lord, that is not in dispute, because, my lord, kindly sees in this paragraph 26, my lord, it is therefore the admitted case of the petitioners that no such contract and a memorandum of understanding was ultimately entered into between the parties for sale of the suit premises. Such contract and a memorandum of understanding, if at all entered into, is not valid and subsisting as on date. So they are saying it has not been entered. Very good, my lord. It's a money claim. I have a claim and I have been given, my lord, a security in that property. Today, that security is being taken away. And what is the ground they are saying, my lord? Kindly takes paragraph 30.
Yes.
During the pendency of the above suit on 13th September, respondent number 1 received information from the people in the neighborhood of the said premises. There is some chaos and disturbance of the said premises, raising cause for concern. Why? It is in my possession. If there is chaos, there can be chaos. On receiving such news, respondent number 1 went to the said premises, and to his shock and surprise found the said premises were abandoned with the main gate left open, with some men present outside the said premises who were creating disturbances thereat. It's a go down, my lord. I don't know how the premises kept open as if, my lord, it's a residential property people are entering. On inquiry from such persons, respondent number 1 came to learn that they were laborers employed by the petitioners who had not been paid their salaries for the past several months, and the laborers were accordingly agitating against the petitioners. Respondent number 1 tried to calm down the laborers and told them to take their claim to the petitioners not to agitate or create any disturbance at the suit premises, which belongs to the respondent. The said laborers thereafter left the suit premises in question, abandoning the same, and there were no persons present in the suit premises employed by the petitioner. Finding the petitioners to be absent from the said premises, having abandoned the same, respondent number 1 employed his security guards to secure the said premises by installing his padlock at the gate. As on 13th September, the respondent number 1 is in actual physical possession of the suit premises. And the petitioners are not in physical or actual possession of the suit premises. if there is supposed to be an actual physical possession, my lord, then two things happen. One is I have to surrender possession. Under the TP Act, I have to surrender possession and they will acknowledge and take possession. And my things cannot be inside.
Correct.
Unless the lease agreement says otherwise. My lord, it is an admitted possession. They are saying my things are there. They are saying this is scrapped. But my things are all there inside. My truck is there. In my petition, I've shown. Because I'm into logistics, my lord. So therefore, my lord, paragraph 31, as stated herein above, on visiting the premises on 13, respondent number 1 found the petitioners to be absent from the said premises. Only a few old trucks, vehicles, tires, and equipments belonging to the petitioner were lying at the said premises. Fearing further agitation and disturbance being caused at the said premises by the disgruntled laborers employed by the petitioner, the respondent was constrained to keep a vigil in the suit premises, as otherwise it would lead to a situation third parties may enter into the suit premises. And then they say that men and agents have lodged a false complaint. My complaint was simpliciter. The 13th, there were people at the premises who were by brute force thrown away. My security guards were there. It's a logistic company. I must have security guards. They were all thrown out and it was taken. And that is why, even as a matter of fact, the police report, but I'm not referring to that too much, but it comes to a conclusion that I was there on the 13th. After 13th, they have come in. Or rather, on 13th, they have come in. Now, kindly, my lord, in paragraphs 24 to 26, my lord, I have specifically stated in my petition that my guards were there.
The guards initially left in order to prevent a loss of life. The guards returned back to the threat and destruction of property. Paragraph 26.
And my lord, 20?
25, paragraph 25 to the
So today, my lord, my case is that on that day, my lord, on that day, my lord, since I was driven away, they took possession. They are saying they took possession. The only thing today is whether they took possession by brute force or whether I had kept it open. I mean, even if I kept it open, my lord, that does not mean that they can take possession.
Have you filed any application for violation of the order?
My lord,
39(2)(a)?
39(2)(a) here, it won't be, my lord, we generally file contempts, my lord.
Maybe, whatever it may be.
No, my lord, we have not filed a 39. We have time, my lord. 1 year is the time period, my lord. But because my lord, may I say, as a matter of fact, that is what my advice was. My lord, 39, my lord, contempt petition, your lordship knows better than me, my lord. In contempt petitions, my lord, generally there are two line of arguments. One is that a court can pass further orders. Another is the court can only pass orders to punish. My lord, that is why, my lord, I've taken out this application because I want the recovery. And obviously, my contempt will follow suit. Has to be. Because I have got 1 year period for that. But this application, my lord, is a substantive application.
1 year period. See, what happened in the land matters or anti-status? If the court has granted in stay in favor of staying the defendant for interfering or enter into whatever it is. If subsequently they have entered, what is the first action of the plaintiff? Either the plaintiff immediately come to the court.
I came immediately.
Correct. Immediately when you filed an application.
My lord, we took leave from your lordship, running here and there, my lord. I know, my lord, at that time, we really pestered your lordship, my lord. Take up this one to take up.
You disposed from 15th.
17th September we came. Immediately, my lord. 15th.
Okay.
So I came, my lord. My lord, again I say, my lord, contempt jurisdiction is, again, my lord, there is a question of show cause and a lot of other things, my lord.
Laborers filed
Now, my lord, my laborers, my lord, they have said that laborers have, my lord, were agitating, my lord. I have replied in my reply that no, this was not the case. Even the laborers, they have come before this honorable court and affirmed affidavits before the commissioner of oath. I have not disclosed intentionally because they will then take the laborers at. They will threaten them further. But I have these affidavits here. I can show you, lordship, and then I can give it to them. So, my lord, today, my lord, saying that the laborers had left or they were agitating, but I'm paying everything is on record, my lord. ESI, I'm paying pension, the Provident Fund I'm taking care of, my lord, everything is being taken care of. And that is there in my reply also.
কিন্তু যে ওরা ওখানে গেছিল, ওখানে লগ ইন করে ওখানে লোকেশনে তোমার অ্যাটেন্ডেন্স দিয়ে দেখাচ্ছে they were there 8:47 my labor is 9:37 AM
My lord, will kindly see the
ফাইল করিনি
my lord, may I just file one of these affidavits, my lord? I will serve. Now I can serve. Act of them. Act of them. Well, this is by one
who's a mechanic.
Moinuddin Ansari, staff of my copy na di ki? আমি একটু পড়ে দেবো আমি একটাই কপি আছে
আমি জেরক্স করে পাঠিয়ে দেব আমি দেখব
এক করে দিচ্ছি আমি পড়ে দিই হ্যাঁ টাইম করে নিতে পড়ে মনে মানে kindly see paragraph 4.
Yes.
On 15th, while I was still on duty, some men, equipment, lathis, rods, and other weapons barged in the garage of the petitioner. My attendance at said place on the 15th. During the time of occurrence of the incident shall be evidence on the proof of attendance, a copy whereof is at Annexure A. And how does he try and show that, my lord? Because obviously they are in possession. My lord, this is it.
এটা স্ক্রিনশট WhatsApp স্ক্রিনশট
না এগুলো কি করে বোঝা যাচ্ছে
লোকেশনটা দেখাচ্ছে লাইভ লোকেশন এখানে
মানে
দেখাচ্ছে দিস ইজ
he has shown is
ওটা অ্যাডমিনিস্ট্রেশন গ্রুপ যেটা আমাদের সেখানে এই করে লগইন করে লাইভ লোকেশনটা দেখিয়ে দেয়
মানে the live location has been shown, that is at Annexure A, that he was present at that premises.
Premises around the area. What is এখানে দুর্গাপুর এক্সপ্রেস লেখা দেখা যাচ্ছে আমি কপি করে দিচ্ছি আমি কপি করে পাঠাচ্ছি
And I'll also give him more than he needs. So, my lord, whatever it is, my lord, there are employees who are saying we are not agitating. My lord, let us come to the meat of the matter. Does it mean that if there is an agitation at a locale of a lessee, the lessor gets a right? But it does not fall under section 108 of the Transfer of Property Act. And Transfer of Property Act is very simple. It's very simple. Now, if you find it open, where is that letter to me? In the entire, if they take possession on 13th, they must have given a note letter. They have not given any letter that we are taking back possession because you are not there in the property.
Yes.
Nothing of that sort. Malat, this taking possession is also contrary to law. So, Malat, this is the circumstances where we are standing today. My property, my movable properties, immovable properties are within that premises also. They are saying coming at a scrap. Your scrap, my scrap, very good. I can just over here or give it back to them. No. That is not the way things travel. That is not the way things travel. Then, Malat, there will be complete anarchy all over. If this is the precedent, that you can take over by brute force. That is why, Malat, Supreme Court and all courts have said, if you have to dispossess, only in accordance with law. Now, Malat, this is the position today. Malat, the legal aspect now. Malat, may I just... $85 दे दे आगे 85 दे 1985 नहीं Supreme Court. And may I start with my lord, Calcutta? Sorry, 85 Calcutta. 85 Calcutta. May I then start with the first? This is well-known judgment when Manohar Chopra, 62 Supreme Court, AIR 1962, Supreme Court 527. will kindly see here, my lord, the Supreme Court in paragraph 43, your lordship kindly takes paragraph 43, my lord, while discussing Padam Sen. But Padam Sen was the first judgment which said that to do complete justice, my lord, inherent powers under section 151 can be assailed of. Here, my lord, paragraph 43, power to issue an injunction is restricted by section 94 and order 39. Not open to civil court is not a chartered high court to exercise that power, ignoring the restrictions imposed thereby in purported exercise of its inherent jurisdiction. So, my lord, what this judgment said, that if it's a chartered high court, it has complete inherent jurisdiction.
Correct.
There, the restrictions under order 39 rule 1-2 will not apply. This is the main judgment. Now, my lord, pursuing this, my lord, may I rely on AIR 1986 Calcutta 220. What's that problem? Okay.
Yes.
My lord, kindly comes. Rachu will kindly find paragraph 7. After taking into contention, my lord, this judgment, my lord, since it's not in Indian court, 151 cannot be assailed of. Then kindly sees 8. Here also, my lord, there is a violation. Now, it may be that order 39 rule 2 is in the nature of an execution proceedings. The question was in whether the court has inherent power to grant a temporary mandatory injunction for the purpose of granting relief to a person who has been dispossessed despite an order of interim injunction. In the instant case, there is no question of execution of the order of interim injunction that was granted in favor of the opposite party, resting the defendants and the petitioner interfering with the position of the opposite party of the room in question, and petitioner is forcibly dispossessed. Then, my lord, kindly sees paragraph 8, just the last sentence before the quotation. The injury is grave and serious. Ends of justice demand that the court should at once take steps in granting relief to the opposite party. In this connection, we may refer to an observation from Kerr on injunctions. May I just quote, but where the injury is of so serious or material a character that the restoring things to the former condition is the only remedy which will meet the requirements of the case, or the defendant has been guilty of sharp practices or unfair conduct, or has shown a desire to steal a march upon the plaintiff, or to evade the jurisdiction of the court, the injunction will issue, notwithstanding the amount of inconvenience to the other party, and though the expense thereby caused to him will be out of proportion to any advantage the plaintiff may derive from it. But I just missed out on one point. I must say this. But the first interim order allowed them to approach this court if they wanted to take any steps otherwise. The order was without the leave of court. So the court was quite aware that if you need to do something, come to court. But they were not prevented from coming to court and saying that they have deserted, I'm taking possession, nothing. It is not in dispute that this property was in a list, pending list.
Correct.
Then, my lord, 9. In a case like the present one, where the restoring things to their former condition is the only remedy, the court, in an opinion, has to take steps for purpose in the exercise of its inherent power. In Bhagat Singh, Diwan Jagmeet Sawhney, it has been observed by Lord Williams, Justice Lord Williams, that the court is not exhaustive. The cases were not provided for in it, and the High Court must not fold its hand and allow injustice to be done. Further, it has been observed by this lordship that the law cannot make express provisions against all inconveniences, and that the court had therefore, in many cases where the circumstances warranted it and the necessities of the case required it, acted upon the assumption of the possession of an inherent power to act ex debito justitiae, and to do that real and substantial justice for the administration of which it alone exists. Then, my lord, kindly comes to paragraph 11, where my lord Manohar Lal and Seth Hiralal has been discussed. My lord, why I showed this, my lord, this judgment made a distinction on Padam's sense case, but it upheld the Chartered High Court's power. Here also, in paragraph 11, thus it is apparent from the said observation of the Supreme Court that no technicality can prevent the court from doing justice in exercise of its inherent powers. Order 39 Rule 2 lays down a punitive measure for the purpose of compelling a party to comply with the order of injunction. The process is contemplated said provision may or may not be ultimately effective, and even the procedure laid down in this is incapable of granting an immediate relief to a party. Well, this is my answer, Your Lordship, my lord, to what fell from Your Lordship, my lord. Because I did say, my lord, it has a process. We do not think that in such a case the court is powerless to grant relief to the agreed party in exercise of its inherent power. The very object of order and rule has been effectively fulfilled by the grant of a temporary and the restoration of possession of the agreed party. The inherent power of the court, as recognized in Section 151, is in addition to the power conferred on the court and the provisions of the court. All that the court is concerned to prevent abuse of the process of court and do justice by immediately intervening under such circumstances. We require such intervention by the court. My lord, after this, my lord, para 14, my lord, the police were required to restore possession, and this order was upheld. Next.
Yes.
Next, my lord. Though this is in a kindly takes, my lord. This is AIR 1992 Supreme Court cases 117. Turab Kawasi Wharton versus Kumisula Wharton. No. Volume 2. My lord, 13, 14, 15, my lord. Here, my lord, again, the Supreme Court was considering a case of status quo ante. My lord, in paragraph 15, my lord, several judgments have been referred to. My lord, I will just take Your Lordship, my lord, Your Lordship will find, I may just read it. In one of the earliest cases of Rasul Karim and Piru Bhai Amir Bhai, Justice Beeman was of the view that the courts in India have no power to issue a temporary injunction in a mandatory form. But Justice Shah, who constituted a bench in that case, did not agree with Justice Beeman. However, in later division bench judgment in Chamse Bhimji, two learned judges of the Bombay High Court took a different view from Justice Beeman, and this view is now prevailing in view in Bombay. In Katswami Chetty versus Subramania Chetty, Division Bench of Madras High Court held that courts in India have the power by virtue of Order 39 Rule 2 of the court to issue temporary injunctions in a mandatory form, and different from Justice Beeman's view. Then, my lord, in Chamse Bhimji, it was held that the High Court was competent to issue an interim injunction in a mandatory form. It was further held that in this case, that in granting an interim injunction, what the court has to determine is whether there was a fair and substantial question to be decided as to what the rights of the parties were, and whether the nature and difficulty of the questions was such that it was proper that the injunction should be granted until the time for deciding them should arrive. It was further held that the court should consider as to where the balance of convenience lies. It was desirable that the status quo should be maintained, while accepting that it is not possible to say that no circumstances of the courts of India have any jurisdiction to issue an ad interim injunction of mandatory character. One Nandan Pictures, this is a famous case. A division was the view that if the mandatory injunction is granted at all on an interlocutory application, is granted only to restore the status quo and not granted to establish a new stage of things differing from the state which was existing at the date when the suit was issued. So I'm not asking for anything new. I'm saying what was there, Your Lordship's court has observed, I'm in possession, give me that. The relief of interlocutory mandatory injunction is thus granted generally to preserve or restore the status quo of the last non-contested status, which preceded the pending controversy under final hearing when full relief may be granted, or to compel the undoing of those acts that have been illegally done, or the restoration of that which was wrongfully taken from the party complaining. But since the granting of such an injunction, a party who fails or would fail to establish his right at the trial may cause great injustice or irreparable harm to the party against whom it was granted, or alternatively not granted, or if to a party who succeeds or would succeed may equally cause great injustice and irreparable harm, courts have evolved certain guidelines. What are the guidelines now? One, plaintiff has a strong case for trial. That is, it shall be of a higher standard than a prima facie case that is normally required for a prohibitory injunction. It is necessary to prevent irreparable or serious injury which normally cannot be compensated in terms of money, and the balance of convenience in favor of one seeking of such relief. Being essentially an equitable relief, the grant or refusal of interrogatory mandatory injunction shall ultimately rest in the sound judicial discretion of the court to be exercised in the light and facts of each case. The above guidelines are neither exhaustive nor complete or absolute rules, and there may be exceptional circumstances needing action. Applying them as a prerequisite for the grant or refusal of such injunction with a sound exercise of judicial discretion. Now, my lord, may I now try and establish these three principles, my lord? My lord, no dispute over the factum that I have a prima facie case that has been already been found, for which I have been passed an order. The injunction is generally passed when the court finds that I cannot be compensated in money. So that has already been found. Therefore, it will now fall back whether injustice has been done. And from the face of it, my lord, the act is an illegality. My lord, let us not think about this matter at all. Can a lessor, I'm taking that, can a lessor or a landlord take possession like this?
No.
They cannot. It's an illegality. Where has the illegality happened? Before your lordship in a list. Your lordship's court was of the view that this property needs to be in a manner in whichever way my ultimate rights will be protected. Now today, my lord, that situation has changed. Therefore, my lord, these tests are fulfilled. Then, my lord, will kindly see. Then, my lord, went into the facts of the case, but not too essential. But here also, my lord, mandatory injunction was passed. And the last judgment.
Any further?
Well, I think these two were. Well, let us hear them, my lord, then I will make my submissions, my lord.
Yes.
Paragraph 16.
You देखा भी है वो?
Or other, if the court changes to the administrator or adversary, in case of partitions.
Well, may I have one more judgment? My learned junior has burnt his midnight oil, my lord.
Which?
Well, this is 2008. AIR 2008 Supreme Court, page
1909.
1909. Though.
Equivalent to 84 SCC 791.
Well, the equivalent is 2008 4 SCC 791. দুটো সেটা দাও না
SCC কত 791
দুটো নেই
আচ্ছা এ না এখন দেব
জজ সাহেবকে দাও যে আরে
এই দাও বলছি
বন্ধ করে সরি ম্যাডাম
Yes.
No. Well, this was in the case of partition suit, but Supreme Court, my lord, please kindly take paragraph 23. Yes, my lord, I agree, my lord. It is the nature of a co-sharer. But my lord, kindly sees the wordings. It is not the law that a party to a suit during pendency thereof shall take law into his hands and dispose the other co-sharer. A party takes recourse to any contrivance to dispose another during pendency of the suit, either in violation of the order of injunction or otherwise, the court indisputably will have jurisdiction to restore the parties back to the same position. I'm on the last part of that paragraph, my lord. Co-sharer, no co-sharer. If I'm disposed illegally, my lord, I have a right of being restored back, my lord.
Yes, sir. How you can take the possession?
What?
How you can take the possession? If it's abandoned, you could have been informed this court. There is an order of status quo, admittedly.
There is no order of status quo.
Kindly come to the order.
Well, may I first place the order?
Yes.
Which
May
is
kindly come to the page 25.
Which is at page
24.
24 of the application.
Yes, page 24.
On my page, the entire order.
Yes.
Plaintiff presented admitted subject to scrutiny by department. Leave under clause 12 is granted. Leave under clause 2 rule 2 is granted. But why am I emphasizing on leave under clause 2 rule 2? I will come to that matter later on.
In view plaintiff seeking urgent interview, clause 12A of the commercial code, leave money, that is not a very big issue. But then in a suit for recovery of money from the defendants, the plaintiff seeks judgment on admission and interim protection. So this is, my lord, principally this is a suit for recovery of money. Property is outside the jurisdiction of this honorable court. So this is the claim on suit for recovery of money on monies that are claimed to be given to us on various heads on whatever grounds that has been made out in the plaint. They say, and the application was taken up by saying that these are admitted amounts and they have not returned the amount. So we need some protection. That's why GA1 was filed. Now, learned advocate appearing for the plaintiff submit that the plaintiffs were put in possession of the immovable property belonging to the defendant as lessees. My lord, kindly mark this. The plaintiffs are consent to pay a sum of in excess of 46 lakhs to West Bengal Financial Corporation upon financial institution seeking take possession of immovable property concerned in view of default defendant paying such financial institution. He submits the plaintiff thereafter negotiated with the defendants for purchasing the immovable property concerned. However, although the defendant initially agreed to convey the same, defendants resiled from such agreement. He submits that now the defendant are neither refunding the amount nor an account ready and willing to convey the property. But the suit is not for specific performance. Suit is for recovery of money. Now, he draws attention to the response issued by defendant number 2. He said that submits the defendants are likely to deal with the immovable property concerned unless restrained. So, his prayer was they will deal with the property unless it is restrained. An advocate for the defendant number 1 might kindly marks this. Are yet to pay lease rental. He submits a sum of 46 lakh odd due payable to the plaintiff and that could short period of 6 months time should be repaid. He submits that defendant number 1 will not sell the immovable property, but the defendant number 1 should be allowed to be mortgaged. But that is a different thing. An advocate appearing for 6 adjournment and receive cause papers. The fact that the plaintiff is in possession of the immovable property belonging to the defendant by virtue of lease granted is undisputed. It is the claim of the defendant number 1 that there are outstandings on account of lease rentals. As on the day of passing of the interim order, it is admitted fact that they were in possession because of the lease and that they were dues and payable. So 46 lakh admitted amount paid to the WBFC and lease rentals. Yeah. Now, why I was emphasizing on the leave of order to rule 2 is plaintiff numbers 1 and 2 are different entities. Lease entered into with plaintiff number 1. Plaintiff number 2 claims to be the person who has paid the WBIFC and claims to have the oral agreement for sale. They have joint cause of action saying the lease, the property being handed over as lease, and that the sale, they are joining their cause of actions today, and now they cannot seek for, they are now come up with novation, they cannot have novation now. So they are both running the case together on the same shoulder, that I have possession on the basis of lease. It is admitted that they have not paid any furthing towards lease rentals. Correct. They cannot show. Till date, they have not shown that they are paid. But they have, what they have done in this reply is they have sought for novation of those lease agreements. But possession on basis of a agreement for sale, the agreement for sale must be registered. Correct. But
the question is, you have not challenged this order.
No, well, what is the order?
On the date of passing of this order also, as per your submission, 46 lakhs was due, whatever it may be. But
let me
good or bad, the order of injunction is...
No, order of injunction is not on possession. Order of, that's why I'm feeling the pain of reading this order.
Complete it.
The fact that the plaintiffs are in possession of the immovable, the claim of the defendant outstanding lease. The fact that the plaintiff paid excess of 46 lakh dues to the defendants are also admitted. The amount is yet to be repaid, but apparently there are disputes and difference between the defendants, defendant partners. This is a different part also. Now, in this circumstance, at this stage, it will be appropriate to restrain the defendants from creating third-party rights over and respect of immovable property without obtaining leave of the court. So the injunction, my lord, is restricted to creating third-party interest.
Correct.
The injunction, my lord, is not on possession.
Correct.
Injunction is not on anything else, but on creating third-party interest because,
At that point of time, the Honorable Court felt that there was 46 lakhs what was to be paid, had to be set off of lease rentals. So as on date, I am protecting the plaintiffs that the defendant cannot create a third party interest.
Okay.
This order was passed on 27th April 2021.
Yes.
When those agreements were subsisting, the lease agreements.
Yes.
But all lease agreements entered into on the same date, 5 consecutive months of 11 months to cover the 5 years. So 55 months plus 5 months.
Yes.
60 months.
Yes.
And every lease agreement has a rental amount to that and has to be paid within a period of time.
Correct.
None of the money has been paid. Now from 21, we are in 24, they have not paid a single pie on us or on rent. And they're in possession from October 2020.
Okay.
Now, as on date, we have shown to my lord, before this Honorable Court, that what money they have admittedly paid to us and what money is admittedly due. We have explained that in a proper chart, my lord, before this Honorable Court. And we have said that as on date, 11 lakhs is due and payable from them. 11 lakhs odd is due and payable from them. Now, on 13th, and my lord will kindly mark, last whole year, GA1 has been adjourned time to time on basis of settlement between the parties. Settlement between the parties, GA1, which is the main application, was been adjourned due to settlement between the parties. Now, since we ran a case that since now they have realized that the rental has become more than that they have given, they abandoned the premises.
Yes.
If premises is mine,
yes.
Premises is not theirs. From 2020 to 2024, they are sitting on the premises, not paying a single farthing to us.
Yes.
And this is, my lord, a court of equity.
Yes.
If a tenant leaves the premises, abandons the premises, what is the duty of the landlord?
Yes.
I come to know from local people that this premises is ajar, doors are ajar, people are fighting outside. I go there and find that it is, or at night it is empty. I put my security guards, because there's an injunction, third party interest. If tomorrow third party rights were created, some third party would have entered, I would have been in violation of this order. I had secured the premises, I have taken possession by securing through my guards. As a landlord, as the owner of the premises, I have every right to secure my premises. And I have done so. I have not violated the order passed by this Honorable Court. I have not created third party interest, which is clear and evident from my affidavit, as also, my lord, from the police report.
Yeah.
Definitely their goods are inside. Definitely, we have said that some goods are inside. What goods? That also are part of the police report. They have done the inventory. So, my lord, what will a landlord do when a tenant has abandoned the premises of the landlord? Is it not the duty of the landlord to take back, to at least secure the premises and take the possession?
Okay.
So 13th, this happens. And whatever affidavit has come is of 15th. Whatever affidavit today, whatever is signing, this is the first time I am seeing that. It's of 15th. So it is an afterthought. Now, status quo, kindly remember the suit premises is not within the jurisdiction. This is not a suit for specific performance. And also, my lord, kindly, if my lord takes the plaint also. Paragraph 13 of the plaint.
Yes.
I will show one line, my lord. how their case for novation goes. Kindly takes paragraph C.
Yes.
Adjustment of rental payable. No rentals were paid. If they are relying upon an oral agreement,
Yes.
and I will come to GA1 later on, but I'm tackling GA5 as of now. I'm not kindly sees one thing I will show, man, kindly takes my opposition and takes annexure B at page 43. This is a chart.
43.
43. Well, there is a chart which is a folding chart.
Yes.
The first part is payments by plaintiff number 1 and 2 to defendant number 1.
Yes.
I will find Middleton tracking, pays security deposit of 4,95,000. Then pays advance for works of 10 lakhs odd. And then this Ritesh Loading, which is defendant number 2, with whom they say that we have an agreement for sale, pays this 47 lakhs. And then pays another 5 lakhs on an account of
Ad hoc rent.
ad hoc rent. Now, what is our due? 11 months we have calculated up to August.
1 crore.
The rentals are given. Those rent agreements are admitted documents.
So as per your case, 1 crore 19 is due.
11 lakh 98.
11 lakh 98,450 is due.
As on my lord August.
After
September.
deducting the 68.
After deducting 60. Clear, my lord. The calculation is clear. But can they occupy my property by not paying a single paisa?
Yes. That's all.
Now, my lord, now, what is their prayer in the application? The prayers are not directed in against the defendants. But the prayers are against the police. There is no prayer against the defendant. That is a violation of the order. That there is no prayer that directing upon this honorable court to direct possession. It's a police direction about the police to do certain acts. My lord, on the first day directed hearing that application, direct the police to file an affidavit.
Yes. Yes.
Third party, my lord, police, local police has filed an affidavit stating the facts. And now, my lord, what they want is T2, injunction that is respondent to forthwith remove all his men and from the ensure the possession stood on 27th April, not change in any manner, how disposal, and injunction restraining from interfering with the possession of the petitioners as on so and so. So they say police will take care of this. The police should take care of this. My lord, if on 13th they choose to abandon the premises, good, bad, indifferent, they have to seek for, if they can show that they have a right over they must have to get an order, they must have a right over the property. So the right of the plaintiffs over the property can only emanate from the lease agreements. According to them, in their affidavits, they have said the lease agreements are novated. Now they cannot rely back on the lease agreement. They cannot approbate and reprobate.
Yes.
But we rely upon the lease agreement by saying that this much money is due and payable. As on that date, as on September that date, you had abandoned. So why they abandoned? Because of what disputes? Because they must have thought that the money that they should have recovered and the money they should have paid has gone more than whatever they should have recovered. They may have abandoned the premises, and they were holding possession not by themselves but through laborers. It was not a direct possession but a constructive possession through laborers. Now laborers abandoned. It is apparent.
Correct.
So what will a landlord, owner of the property, not landlord, or owner of the property do? Will he not secure the premises? But we have just secured the premises. We have not thrown away the goods. We have secured the premises. We are now in possession, and my lord, after the return on the returnable date, my lord, at that date, status quo to be maintained.
Yes.
Status quo is on that date, and that day status quo is being maintained, my lord. My lord, status quo ante is, my lord, kindly give that judgment to Supreme Court judgment. Judgment. My lord, this is not a suit for land.
Admitted.
This is a suit for recovery of money. And if we can prove in the suit ultimately that we get money, they ultimately get nothing in the suit.
Have you filed the cross counter claim?
We have filed our written statement. My written statement is pending.
Statement has been kept on
record,
subject to outcome of their application for acceptance of the written statement.
Whether you
Yes,
along with the
it is
counter
beyond
claim?
time.
Along with the counter claim?
No
The written statement, there is
no
a counter
counter.
claim. No counter
No
claim.
counter. But we have said in the written statement, we have taken the point of adjustment. Set off we have pleaded. As on the date of filing, the money was
due.
No. Money was to be paid to them.
Oh, that's why.
As on that day when we affirmed the written
So
statement.
that's why you're not filed the counter claim. Okay.
And one aspect I would, my lord, kindly takes. But I have not gone through the facts of each case. My lord, every case is based on its facts. But I will now rely on only one, that Dorab, that 1992 Supreme Court cases, my lord.
(1990) Volume 2.
Volume 2. Dorab Kawasji Warden versus Kumi Sorab Warden.
Correct.
And it takes paragraph 16.
Yes.
A status quo as on the date of interim order cannot be the status quo which is contemplated here. Okay. Status quo has to be on 13th, as on 13th. Now, what is there? No, it is the non-contested status. So this is a contested status. It is not a non-contested status. I am saying they have abandoned. They are saying I am thrown out. I am thrown out.
Yes.
They are saying we were thrown out. I am saying no. They had abandoned. I had taken possession to restore basically to protect my property and secure my property. And now, my lord, kindly sees the 3 guidelines. The guidelines say the plaintiff has a strong case for trial. This is not an issue of the suit. Possession of the property is not an issue of the suit. So there is no case for trial here. Then it is higher standard than the prima facie case for prohibited injunction. But what is the standard? It is affidavit versus affidavit. It is affidavit versus affidavit on basis of 2 affidavits, counter affidavits. Now, is it a case a prohibitory order. There is no order of injunction restraining to disturb their possession. It is only for not to pay
Alienating.
third-party interest.
Alienating, yes.
And my lord, when I deal with the judgment upon admission, I would say that there is no occasion to I will ask for variation of that order because more money is being payable. That order was passed since 46 lakhs was due. So do not get third-party interest. We said we'll pay 46 lakhs. By mortgage, at least allow us a mortgage, then we pay 46 lakhs. Court was on that view on that day that if they mortgage, third-party interest created, something will happen. So let us not give them a third-party interest to create. Let them get their money. And the court has recorded that there is due of rental dues. So strong prima facie case for going to trial is not there. Prevent irreparable serious loss normally cannot be compensated in terms of money. Irreparable loss is to me. The loss and injury is to me, not to them.
Because of the due against you.
Yes. Second, third, balance of convenience. Balance of convenience, my lord, here completely lies with the defendants.
Yes.
The balance of convenience completely lies with the defendants who, and my lord, may I refer to section 56, 59 of the Contract Act once, which says that if a money is being paid, how it is to be apportioned. How will I take the money? Appropriate the money is on my account. Provision table.
Yes, next.
My lord, another thing, the value of the property as on date is more than 4 crores. The value of the property as on date is more than 4 crores.
That is not the criteria at this stage. It is
not, but property is a valuable property. So, my lord, as on date, if status quo is maintained till the hearing of the GA1, but it will not harm anyone. But GA1 is their main application for judgment upon admission, where the injunction of third-party rights is created. But if that is vacated in GA1,
then
automatically everything goes well.
Anything further?
Nothing.
Yes.
Yes. Well, some things Mr. Lahiri has submitted, which are beyond the scope of the pleadings. So I will just restrict myself to the question which is saying is that my claim in the suit is for money. But the question in this application is not that. If my claim in the suit is for...
Only the question is that, see, you had argued and you filed this application on the basis with regard to the possession of the...
Yes, my lord.
Correct.
Yes.
Might be this court has recorded you are in possession.
My lord, yes, my lord. I have understood where it's coming from, my lord. Then the court...
No, my lord, the operative portion, when the court has passed an order for injunction, court has only passed an order restraining the defendant to creating...
With humility, my lord, I understand that part. My lord, may I just try to take it in this fashion? Let us say that first, that part is not there. That paragraph is not there. Because the next paragraph starts in such circumstances.
Maybe.
Or else it wouldn't have recorded that.
Correct.
Therefore, my lord, that was what was kept into contention, that is the entire status, that I am in possession and in such circumstances, this is the further order.
Correct.
So today, my lord, whether I am in possession or not, that was considered, and while passing the order, that was given. So today, what is the case my learned friend is running today? My lord, let us just keep that aside for a moment, my lord. There is no dispute that I was in possession. Today, my learned friend is the money, therefore they took possession.
No, not that case.
My lord, first, my lord, that is their one protection. Next is, what do we do if they have abandoned? But this question of abandonment is obviously not there because I'm claiming it. I've come within 4 days or 2 days.
2 days, 15,
2 days.
17 I filed.
So there's no question. Next, my lord. Abandonment. Where is the notice? Where have they given the notice that it's been abandoned?
Okay.
Now, my lord, I have relied on 89, my lord, the Calcutta judgment, my lord. Calcutta judgment goes further, saying that if injustice is seen, your lordship will do the needful.
That's why, see,
Now, what is the injustice? My lord,
what is the injustice? See, with regard to the possession, it is not your case that you have been thrown out and all the things. You are not in a position to carry out the business or the premises. Your business has been hampered or whatever.
Yes.
Correct. It is not the case here.
My lord,
You have only simply filed an application stating that order passed by this court has been violated. They have taken the possession forcefully. That's why the police
my lord, I have also said so that I was in business. My business has been.
But
My lord, yes, my lord, because I have said that I had.
and that is not the case in your main application with regard to the business. The status quo order of injunction is
No, my lord, that
only
is.
with regard to the court
My
has
lord,
taken into consideration 3 things. First, with regard to the your possession, first it has been taken into consideration.
first application.
Then the 46 lakhs, which the defendant has to return the amount to you. That's why taking into these 3 aspects in consideration, court has passed an order to save your interest with regard to payment, return of the amount. So no
Yes.
third party interest should
My
not be
lord.
created, so that in future your decree will be passed. So
Right, my lord.
your decree cannot be on the black and white.
So, my lord, today, my lord, since I'm in possession, my lord, I have not been required to ask for that possession to be kept with some receiver, anyone.
But the court has not passed an order
No,
with
no, my
regard
lord,
to the
my lord.
disturbing the possession. You might be on that day, you are in possession. But the
Yes.
court has not passed any order, mandatory injunction or interim
My lord.
injunction or temporary injunction restraining the defendants for interfering the possession of the property.
My lord, have first application. My lord.
If that word would have been in there, then all the judgments which you have relied upon, what you have made the submission, then it can be. But the court, taking into consideration, has not passed an order not to disturb the possessor.
Under the court, in my judgment of an admission, my lord, there are 2 parts. It was a judgment of admission and also Order 38 Rule 5. So the court has protected me to that extent, finding me in possession, that in such circumstances, they will not deal with it without leave of the court.
Correct.
So, my lord, when I am in possession, whether I am in possession or not, my lord, that was a dispute before this honorable court because they were saying I was put in possession, I did not pay these rental, that was being looked into. So, it is not that this point of whether the property was in my possession or not was not of consideration of this court. Today, my lord, let us say I am not in possession. What is the value of this injunction, my lord? My lord, let us say I am in possession. Can my learned friend give out in any further way? Let us say a lease or something without taking away, without possession.
But you, by way of this application,
Well,
can the court say, no, you have to give the possession when there is an order? This is not an application for modification of the order.
No,
You have not filed an application
I'm
for
saying
modification
status quo.
of the order.
I'm saying status quo.
Is that, sorry.
But
Can you
status
see the
quo.
prayer?
Yes, my lord.
Can you see the prayer to direct the police authority to put you in the
My lord,
possession?
two.
Yes.
But it's just that, my lord, the my lord,
Direction upon the police to Hubli to
no,
file
that
a
is
report.
one.
That
No,
is
my lord.
over.
But
That
kindly
the
see,
court
my lord.
should remove all its men and agent from the premises and to ensure the
Yes.
its
Position as it stood on that date.
as on that day.
That is status quo ante.
But where is the order of status quo? Where is the order of status quo on the
My lord,
24th?
status quo, my lord, with humility, my lord, status quo may be an order, or status quo, the meaning of status quo is status as on that date.
That's why I'm telling again and again.
But a status
the
as
last paragraph, though the court has recorded with regard to the possession,
But
but consciously this court has not passed an order of any injunction with regard to the possession.
because I was in possession.
That's why not. If you are in possession,
That is why-
the court could, you could have been prayed for the court. I am in possession. You are in danger possession. They may disturb your possession. Let the status quo order with regard to the.
Malad, the contention with humility. That is why I'm submitting, Malad. Malad, the
And
court.
this application, please also you take note of it.
Malad.
This is not an application for modification of the order.
No. I'm not asking for modification. Malad, I'm saying the court on that day found a status. Malad, it does not mean that the court has to say status is as such and such and such and such. I am saying the court found a status
Correct.
of possession.
Correct.
Who was in possession? Court found I'm in possession.
Correct.
In my prayer, I have said status quo as on that date.
Correct.
So what was the status on that day?
Hmm.
I was in possession, which this court found. That is what I was sought for. I'm not asking for any modification.
Okay.
I'm not saying that you will not hamper my possession. I'm saying you have illegally taken possession, disturbing the status found by this court.
Okay.
Status quo and injunction, these are two different things. With humility, my kind of I am saying status quo. What is the meaning? The meaning is the status
Status
is
quo
to be
they are-
maintained.
They're also admitting status quo as on date.
Yes, now the date. Now we'll have to
As
see.
on the date when I have passed, this court has passed an order.
Malad, that was pending this application.
Pending this application because
It wasn't a final order, Malad, in your lordships. It was pending. So now we'll have to find out which date will be the status quo. Which date?
So that's why I'm asking. If you wanted the status quo from 27th of April
Malad.
2021, then whether this court can pass an order for status quo as on 24 in this application, because this is not a modification, variation or anything.
Malad, I'm asking for mandatory injunction of status quo ante.
But there is no order of status quo on that 24th of June.
Malad, again, I submit with humility. I don't think I'm making myself clear, Malad. Malad, there is two ways of passing an order. The court could have said, I find you in possession, status quo. Because status quo is a very strange word, Malad. It needs to say about what? Very important. Because status quo means status quo, like my learned friend is saying. So, Malad, status quo as on possession. Why I'm saying this? The court found a status. Is that in dispute? That is not in dispute. Now, Malad, which court will pass me or grant me this order of status quo ante? That has to be the interrogatory court.
Correct.
So the point is, the word status quo not being there in the order.
Status quo ante. Status quo simply.
Ante as on today.
That's why. Status quo simply, that is the entry.
That is in the past, in the future.
Future.
Status quo ante is as on the date of the list.
List. Correct. Status quo ante.
Yes.
Status quo ante when the court will consider whether on that day
Yes.
there is any order of status quo passed by the court.
Malad,
Not
with humility.
Only not by recording the submission.
It is not a recording of submission, Malad, with humility. It is not a recording of submission, the finding of the court.
Finding might be, but the
Malad,
but the operative portion, what the
operative portion takes it. Malad, may I just read that order once, Malad?
Correct.
Because now everything hinges on that.
correct.
Because, Malad, the operative portion, your lordship kindly takes.
Because the operative portion in such circumstances,
Yes.
in such circumstances,
What
to
circumstances?
be consider these three aspects.
No, Malad, kindly see.
These three aspects.
There are three aspects and there is a finding. There are two different things there. But kindly, may I just place those two last paragraphs?
Yes.
The fact that the plaintiff are in possession
Correct.
of the immovable property belonging to the defendants by virtue of lease granted is undisputed.
Correct.
So that is a finding of the court.
Okay.
So the status of the plaintiff as in possession on that day is found by this court. That is an order of this court saying that yes, you are in possession.
But yes, continue then.
Therefore, Malad, it is the nature of a declaration also, if required.
Correct. Then
It is. My learned friend has not disputed that. He has not gone up in appeal.
correct.
So that is a finding of this court. So the status has been found by this court. Then it is the claim of the defendant number one that there are outstandings on account of lease rentals. I would have expected Mr. Lyrie to take the actual case, but in my petition, Malad, in the plaint also, the 92 lakhs are due and payable. He should have shown that. He's completely given a disregard to that. Why 46? 46 was the only amount which we gave to WBFC. There are documents in the petition.
Where they admit this payment.
And this 92 lakhs is admitted in the WhatsApp by WhatsApp. That is why judgment upon admission. He should have said so when showing that chart. He should have said so. He has not given that.
Yeah.
Just writes the 62, 68. He should have said so that is what the court found. Then sees. It is the claim of the defendant, number one, there are outstandings on account of lease rentals. Now, this is the claim. This is not a finding by the court. The fact that the plaintiff paid sum in excess of rupees 46 lakhs, as kindly see, is excess.
Correct.
That's why it's not 46.
Correct.
On account of dues of the defendants to the West Bengal is also admitted.
Correct.
The amount is yet to be repaid by the defendant. Apparently, there are disputes and differences with the defendants. The defendants are partners of a partnership firm. They have their problems. Now, there are two parts in this paragraph, my lord. One is a clear finding of the court, declaring a status. And the other is diverse claims, which the court says I will deal later. So, as on that date, court found that I am in possession. Then, in such circumstances, takes into contention that I am in possession. In such circumstances, at this stage, it is appropriate resident defendants of creating any third-party rights over and in respect of the immovable property concerned without obtaining the leave of the court. Now, when I'm before your lordship, my lord, let us say, my lord, this finding was not there, that I'm in possession. That would have completely changed the scenario. Because then, in such circumstances, wouldn't have taken into contention, my lord, that part. That I'm in possession. That wouldn't have been there. Then it would be simpliciter. But when I'm in possession, let us say I've abandoned. That is why the leave of the court was given. There was no leave taken from your lordship's court.
No, leave with regard to the
Yes.
third party.
Why, my lord? Because third-party rights, from creating any third-party rights over in respect
Leave.
of the immovable property.
Without the leave of.
Without the leave of the court. How will they create if I'm in possession? My lord, why can't I? Because that was sought for, that was not given. They specifically asked for that to make mortgage. That was not given. So, my lord, today, what are we looking at? We are looking at an order of court declaring that I'm in possession. On the basis of that, further orders are passed. I'm not saying restore that order. I'm saying on that day of passing of that injunction, the status which was there, that should be maintained. Because the interim order was passed on the basis of that status. Now, my lord, I do understand that we fall into, my lord, the dells of this, my lord, the regular principles that mandatory injunctions ought not to be granted. My lord, that is in our, we as lawyers, as judges, that does not mean we have this, that it is a very high, I also submit before your lordship. Like in bank guarantees, my lord. When we come to court, there is no chance. But my lord, there are certain cases where this ought to be applied. That is why the Supreme Court has also said so. My learned friend showed paragraph 16, but he did not show the paragraph after that, where it was specified that these guidelines are only for guidelines, not binding. You'll have to find out. And what is the test? That's the Calcutta. Saying that whether there has been injustice. My lord, if today I was not before your lordship's court and I was dispossessed, then what would have happened? That's a different. But because your lordship's order has accepted my status and declared that yes, as on date you are in possession. Therefore, I'm saying status quo with regard to that. My learned friend says 2 days, as on 13th, just because the lordship has passed. That lordship, I also pointed on that day. Your lordship says till date, because I cannot hear it out, I'll pass this, but I will consider your application. And obviously, that was an interim order in this, so it wouldn't be binding as such. But which is the date when which we should have status quo? My lord, the Calcutta High Court's judgment says, and also the Supreme Court, on the non-contested status. My lord, when was the non-contested status then?
Had interim.
When at the very beginning, that was the non-contested. After that, everything is contested. Therefore, the date, my lord, there is no scope. It has to be on that date. And my lord, your lordship being a chartered high court, my lord, that is the difference. That is why, my lord, I placed that other judgment, my lord, the first judgment. It requires a chartered high court to overcome all injustices. Ex debitio justitiae. That is the word used, my lord. Beyond the pleadings. Today, my lord, if your lordship's orders, my lord, whatever it is, good, bad, or indifferent, my lord, today may I say this. Let us say my learned friends now come before your lordship's court and say, my lord, I have got leave. Grant me leave because I am in possession. Will it or will it not change the nature of the first order? It will.
The circumstances depends.
No, my lord,
They will come. Then
no, if my lord, today, my lord, a property which is in my possession, if dealt with, and a property which has been taken possession of and dealt with, will have completely different ramifications. Even, my lord, consideration of the leave will have completely different ramifications. If I'm in possession, if I'm not in possession. So, my lord, does affect, my lord, at the worst case, it is a security given by this court to me. It is a security. If they say it's a money claim, they have not gone up in court in appeal. So I cannot, they are not entitled to take that point here. He was arguing the matter at hand. The point is absolutely different. If they say that that money part has been crossed, they should come to your lordship's court. So, my lord, today, whether there has been injustice or not, is this an illegal act or not?
yes.
It is of no consequence whether property is within or outside. It has been treated as a security. Then, my lord, there will be, my lord, any order can be just dealt with like this. So, my lord, kindly, I beseech your lordships. My lord, there are cases where, my lord, orders which are required to be protected by such status quo or interim orders. On the face of it, the status has been changed. At the time of the list and as on today.
Okay.
When the list was before your lordship.
Okay.
These are my submissions.
There should not be a reply to reply, but my lord, the Calcutta judgment, my lord, if my lord goes through, there was a specific injunction restraining not to disturb possession.
When offering for the plaintiff, when offering for the defendant. The plaintiff has filed the present application GA Com 5 of 2024. Praying for direction. Praying for injunction, directing the respondent to forthwith remove all its men and agents from the said premises and to ensure that the position as it stood as on 27th of April 2021 is not changed in any manner whatsoever till the disposal of the suit. And he has also prayed for several orders upon the police authorities. Police. By an order dated 20th September 2024, this court has directed the Superintendent of Police Hooghly, ruler, to depute a competent officer to inspect the premises in question and to see whether the order passed by this court dated 27th April 2021 is complied with or not, and if it is not complied with, to take appropriate steps against the persons who have violated the order and to submit the report before this court on 24th of September 2024. In compliance with the order dated 20 September 2024, comma, the Inspector of Police Officer in charge, comma, Haripal PS Hooghly had submitted the report wherein it reveals that on 16th of September 2024 at 1:25 hours, the police officer in charge of Haripal PS received a written complaint from one Santosh Singh to the effect that, as per the order passed by this court, the plaintiff was in possession of the property, but on 15th of September 2024 at about 14:20 hours, the alleged persons, namely Rohit Saraf, and the one person, namely Rohit Saraf, violated the order of the court by entering into the suit premises along with the 15-20 persons, which was in possession of the plaintiff. And accordingly, on receipt of the said complaint, the police has initiated an FIR. And investigation has been carried. It is further stated that during the investigation, the police has visited the premises and found that several articles such as truck, JCB barrels containing fuel, old tires, tirpal, scraps, tables, chairs, etc. are found within the said premises. An inventory of the said articles have been made by the police in presence of the witnesses. Police of the The investigation and the report further reveals that, as per the investigation of the case, the police came to know that Rohit Saraf, along with his employees, have taken up the possession of the premises in question as per the direction possession, have taken possession. Counsel for the plaintiff submits that by at the time of passing of the injunction order dated 27th of April 2021, this court has categorically recorded that the plaintiffs are in possession of the immovable property belonging to the defendant by virtue of the lease granted is undisputed. Counsel for the plaintiff submits that on 24th of July, 27th of April 2021, admittedly the plaintiffs are in possession of the property. He submits that it is also admitted from the affidavit in opposition as well as the police report, the defendants have taken possession of the premises in question. And as such, the plaintiff prays for anti-status quo order by directing the police authority to put the plaintiff in possession of the premises as on 27th of April 2020. In support of the submission, the plaintiff has relied upon the judgment reported in AIR 1986 Calcutta 220 and submitted that restoring things to their former condition is the only remedy. The court can pass appropriate order by exercising the inherent power by putting the plaintiff in possession of the suit premises. The plaintiff has also relied upon the judgment reported in 1961 SCC Online SC 17 and submitted that power of issue an injunction is restricted by section 94 and order 39, and it is not open to the civil court, which is not the chartered high court, to exercise the power, ignoring the restrictions imposed thereby. He submitted that this court is the chartered high court, and as such, this court has the power to exercise the power, ignoring the restrictions imposing under section 94 and order 39 of the Code of Civil Procedure. Learned counsel for the plaintiff has relied upon the judgment reported in the case of reported in 2008 volume 4 SCC 791 and submitted that if the court finds that the order of injunction is violated, the court has the jurisdiction to restore the possession of the parties, to restore the parties back to the same position. Counsel for the plaintiff has relied upon the judgment in the case reported in 1990. 1990 volume 2 SCC 117 and submitted that interlocutory mandatory injunctions are granted generally to preserve or restore the status quo of the last non-contested status quo, which is preceded to the pending controversy until the final hearing when the full relief may be granted, or to compel the undoing of those acts that have been illegally done, or the restoration of the restoration that which was wrongly taken from the plaintiff. Counsel for the plaintiff submits that in the present case, on 27th of April 2021, this court has come to the finding that plaintiffs are in possession of the immovable property belonging to the defendants, and accordingly, this court has passed interim order. But on 13th September 2024, the defendants have forcefully taken the possession of the premises of the suit property, and as such, the plaintiff is entitled to, and as such, the possession of the plaintiff is to be restored in its original possession in terms of the order dated 27th of April 2021. Per contra, learned counsel appearing for the defendants submits that there is no order of there is no interim order with regard to possession of the property is passed in favor of the plaintiff. Counsel for the defendant submit that though this court has recorded that the plaintiffs are in possession of the immovable property, but while passing the order, this court has only restrained the defendant from creating any third party right over and in respect of the immovable property concerned without obtaining prior leave of. He submits that there is no order with regard to status quo with regard to the possession and status quo over the property, and as such the application filed by the plaintiff is not maintained. Counsel for the defendant submit that the suit filed by the plaintiff is not for the specific performance of contract and not for the land. He submits that the land, not for the land. He submits that the land is situated beyond the jurisdiction of this court. Counsel for the defendant for the submitted plaintiff has not filed a suit for a specific performance of contract. Plaintiff defendant a specific purpose of contract. The counsel for the defendant has relied upon the document being Annexure B, page 43 of the affidavit in opposition, and submitted that the due an amount of rupees 68,42,000 was due and payable by the defendant to the plaintiff, but the plaintiff has not paid the rent with respect of the suit property to the defendant, and as such the total due is payable by the plaintiff to the defendant, being the rent of the suit property, is rupees 80,40,450, and thus an amount of rupees 11,98,450 is recoverable from the plaintiff, and as such the defendant is not liable to pay any amount to the plaintiff. Counsel for the defendant further submit that if there is no order of status quo with regard to the possession of the property, and as such this court cannot pass any order of anti-status quo by putting the plaintiff's possession over the property. He submits that on 13th of September 2024, the defendant has received an information with regard to some agitation in the suit property, and when the plaintiffs when the defendant reached the place of occurrence and the suit property and found that there was a dispute, and there was a labor dispute and there is a dispute between them. There is a dispute of the laborers of the plaintiff on the ground of non-payment of salary of the plaintiff to the laborers, and accordingly the laborers have left the suit property, and the suit property was kept abandoned, and thus to keep the property safe and intact, the defendant has taken possession of the property and kept the security guard over the said property for the purpose of security of for the purpose of safeguard of the property in question. Counsel for the counsel for the defendant submit that the application, no order can be passed in the present application, and as such the application is required to be dismissed. Had the learned counsel for the respective parties produce the materials on record and the judgment relied by the plaintiff, this could find that by an order dated 27th of April 2021, this court has passed the following order, page 25, 26. Although this court has recorded the finding that the plaintiffs are in possession of the immovable property belonging to the defendant by virtue of lease granted is undisputed. But while passing the order of injunction, this court has only restrained the defendants from creating any third party right over and in respect of the immovable property concerned without obtaining prior leave of the court. The contention of the plaintiff that this court has recorded the finding that the plaintiffs are in possession of the immovable property belonging to a defendant by virtue of the lease granted is undisputed, and as such, granted is undisputed, and now the defendants have taken possession of the property in question, and as such, an order of anti-status quo is to be passed by restoring the possession of the plaintiff for the suit property. This court find that though this court has recorded with regard to the possession of the plaintiff for the property, but considering the whole aspects of the matter, this court has only restrained the defendant from creating any third party right over the property without the leave of the court. This court has not passed any mandatory direction directing the parties to not directing the defendant not to disturb the possession of the plaintiff or the property. It is also not the case, it is the specific case of the defendant that the landed property was abandoned, and as such only to safeguard of the property, the defendant has taken possession of the property and kept a security guard for the purpose of safeguard of the property in question. The defendant further submit that he has the defendant during his submission has submitted that they are not going to create any right and create any third party interest over the property. He further submit that it is not the case of the plaintiff that the defendant has created any third party interest over the property. The counsel for the defendant further submit that he has no objection if an order of status quo which has been passed by this court after receipt of the report of the police as on 17th of September 2024. Considering the above, this could find that the judgments relied by the plaintiff is having a settled possession of the law, but the said judgments are not applicable in the present, is distinguishable from the facts and circumstances of the present case, as in the present case there is no order of injunction with regard to the possession of the property. If the interim order with regard to the possession of the property and the defendant has forcefully taken the possession of the property during the status quo order, then the judgment relied by the defendant could have been applied. Plaintiff could have been applied. Considering the above, this court finds that the application does not have any merit. According, the same is dismissed.
Well, kindly fix the date for GA1.
It is submitted that the interim the injunction application being GA1 of 20.
Not injunction, my lord, application for judgment upon admission.
No, also injunction. It is injunction also.
It is submitted.
GA1 minute. Keep it
GA1 of 2020.
1 minute.
2021 is pending for disposal. Let the same be listed. We listed on 19th of November 2020.
Before your lordship,
Yes.
rise, item number 6. I was waiting. I was.
I'm 5.
No, I'm 6. Kindly, I'm only waiting for not today. Second half. Item 6. My missed job is on the other side.
You are having anything?
I'm at 5. Next one.
5 if you called at 2 p.m.
Your lordship,
Item number 6. Kindly make it not today only.
I am plaintiff, your lordship. Kindly keep it
My-
tomorrow, your lordship. It's a very small matter.
Who is in 5?
5, Mr. Ray. Tomorrow 5 ache. He's in 5.
After 2? At 2?
Whenever, my lord, because my lord, I have 1 minute only.
At 2
My lord, I was arguing a case before lordship with regard to the master having jurisdiction
That
in
was.
commercial. Yes. Now, my lord, your lordship has already passed an order, but with humility, my lord, I will again argue that because my lord, that contention, my lord, because on the last day I did not argue because I was not briefed. My lord, that contention has not been considered. So I would like to. This is a separate matter. Separate matter, same point. But my lord, that the master, whether he has jurisdiction under the Commercial Courts Act, but with humility, your lordship has not been shown that. So that I would like to argue. That is the next matter, my lord.
So what do you want?
Argue kar diye. But I am ready to argue. I'll come at 2.
Okay, come at 2.
Lordship,
6.
kindly
Make it not today.
kindly keep it tomorrow, your
Which
lordship.
one?
6.
Item number 6, your lordship. Mr. Sharma is having.
I am the applicant. My friend is the plaintiff.
What is the application?
Lordship, this is.
Application is for extension of time to file the written.
So 120 days already.
For the plaintiff.
Oh no, she's.
So I am for the plaintiff, your lordship. 120 days already over, your lordship, and I'll show you this application is not maintainable.
No, my case is that the 120 days will run once I get the summons. Here, summons has been served upon.
No, your lordship. And I'll show you, lordship, the summon has
It
been
will
served on the
take some
registered
time,
office
my lord.
of the company, your lordship.
Completed.
Yes.
Lordship, evidence has been. We
Okay,
we have also completed evidence, your lordship.
No.
Now they're coming.
It was yes when we came and we intervened, my lord.
Yeah.
Come on.
Expert.
Right.
Come on, 8.
Yes, my lord.
8th.
Tomorrow is the non-commercial matter.
Lordship.
Yes, and 8th, my lord.
8 or 9?
8.
8th, lordship.
8 कौन सा दिन है? Friday.
Friday.
Yes, then
Lordship, kindly
Friday.
fix a time, your lordship.
I'm no.
Lordship, the top of the list, your lordship. Kindly, your lordship.
Item number 6. So suffering for the plaintiff, so suffering for the defendant. Full list of defendant has filed an application for extension of time to file return statement. It is submitted that the pleadings have been completed and the matter is ready for hearing. In view of the above, let the matter appear on 8th of November 2024 under the same heading. Yes, next.
My lord, with humility, my lord, item 5 may be kept on the 8th, my lord. Similar order, if your lordship. I said I'll come at 2, my lord. My junior has some problem. I need my junior.
8 also, the 5 also same order. Only 5 as per the submission made by the counsel for the respective party, let the matter appear on 8.
Grateful, I'm sorry.
Yes.
My lord, subject to your lordship's leave, my lord, item number 9, my lord, my other side is there, my lord.
For the defendant
My
in this
lord,
matter, your lordship.
I am for the plaintiff, my lord. My lord, the instant suit is at the stage of, my lord, examination of witness of defendant. Meanwhile, they have filed one GA for disclosure of certain new documents, my lord. My lord, the GA was heard time to time, my lord, and it was reserved for passing the judgment in the year 2023, my lord.
By this court?
No, my lord. Earlier bench.
Coordinate bench. your
Coordinate
lordship. I'll
bench.
tell your lordship what had happened.
So what has happened?
My lord, the judgment has not been passed yet, my lord. We have mentioned it.
Now?
My lord, kindly fix it after fortnight, my lord. In the meantime, I'll mention before the coordinate bench.
Commercial case could be like this, madam. If the judgment is not delivered, whatever the document, let the court proceed with that. What can
The
be done?
lordship will give me leave to appear in this matter, my lord.
Yes.
I am leading her, my lord. My lord, the application judgment was reserved. Commission was being conducted, and the second witness of the defendant was to give evidence.
Yes.
At this stage, my lord, the defendant made an application praying for disclosure of new documents. That application has been heard out, and thereafter it has CAV has been done, my lord. But we are awaiting the results of that application. Unless and until the results of that application come, we are in a predicament. I being the plaintiff, I am being prejudiced the most. But we cannot proceed with it.
So what can be done, madam? The commercial suit. So since when the judgment is?
I leave it to your lordship. It is
17th October 2023, your lordship.
I am fixing after 2 weeks. Then if
Let fortnight, my lord.
my lord. May I have your lordship's leave, my lord? Item number there's another connected suit within the same parties, my lord, where your lordship has to give some directions because we are awaiting proceeding with that also, my lord. My lord, in that suit, it is item number, lordship will allow me a moment's time. It is item number 35.
Yes, 35.
My lord, in that, my lord, the affidavit of admission and denial has to be filed. I believe my junior is there with the affidavit. Lordship will allow us to file the affidavit and fix a date for framing of issues, my lord.
Who is for the other side?
My lord, I appear
Lord,
for the
we-
defendant in both the matters, your lordship. In the second matter, the affidavit of admission and denial is to be done, but inspection has been carried out.
Record item number 9. So-and-so appearing for the plaintiff, so-and-so appearing for the defendant. It is submitted that the defendant has filed an application for
Yes, your
additional
lordship.
documents.
Application
Yes,
under
ma'am.
order
Filed
11,
an
your lordship.
application for bringing some additional document on record, and the coordinate bench of this court has already heard the matter, and the matter is kept for CAV. In view of the submission made by the counsel for the parties, the case adjourned for 2 weeks. Please the matter on 29th of November 2024 under the same heading. Record the 35. So-and-so appearing for the plaintiff, so-and-so appearing for the defendant. Yes, where is the document? Who is filing? Affidavit documents.
My lord, I don't have the document
Don't
right
have the
now.
document. Okay,
My
come
lord,
after lunch, you bring that.
My lord, may I be permitted to mention that 12 and 19, my lord.
Huh?
12 and 19, my lord. Today's list.
Come after lunch. Come after lunch.
Change in brief, the process is still going on. We are
Who's
yet
for
to
the other
obtain,
side?
we are yet to obtain no objection, my lord.
That's why. Where is the other side? Other
No,
side
no,
is.
I will come.
Come.
the invoices, certain part payments were made. My lord, a sum of rupees, my lord, 19 lakhs odd is payable. May I, lordship, may I quickly take your lordship through the documents, my lord? My lord, the export.
What is the prayer? Injunction? Interim order?
No, your lordship, for judgment upon
Judgment upon
admission.
decree.
Yes.
Upon
Your lordship,
admission.
checks were issued twice, and there are, my lord, acknowledgements in email and ledger acknowledgements also. So, lordship, may I show you the documents briefly? My lord, the export invoices which I had raised, my lord, is from pages 21 to 25.
These are the invoices.
Yes, your lordship. My lord, they have not disputed
What
the
you have supplied?
My lord, we had provided services. My lord, we are freight forwarders. My lord.
Achha,
Yes, my lord, we had forwarded the leather goods of the defendant and thereafter raised the invoices. My lord, they have not disputed. My lord, we made demands saying that these invoices are payable. If your lordship sees the invoices, my lord, from page 31, your lordship will see 20 Cube Logistics is, my lord, the plaintiff before your lordship, and Paramount, my lord, is the defendant. Your lordship, it says that terms 30 days from invoice date. My lord, they did not make payment. So we, my lord, made demands. My lord, in reply thereto, my lord.
Page?
My lord, page 31 to page 43 are, these are, my lord, the invoices. There are 7 invoices in total.
So what is about 21? That is also invoice. 21 to?
Lordship, 21 to 25 are, my lord, export invoices. My lord, these they had, my lord, given to us in terms whereof we were to, my lord, forward the freight.
So as per the page 21, exporter was the Paramount.
Yes, your lordship, the defendant.
The consignee is the premium.
Yes. Lord, that is a party they were exporting to. My lord. Yes.
And so how it has come to you?
My lord, they had by email, my lord, asked us to transport the goods. My lord, from page 26 are the emails.
Okay.
My lord, they gave us these, my lord, export invoices. Goods were to be transported in terms of the export invoices. My lord, they do not dispute this. My lord, they admit that I have rendered services.
Correct.
Now, your lordship, when payment was not forthcoming, my lord, we made demands. Thereafter, my lord, they have made several acknowledgements. My lord, if your lordship takes page 54, Lord, on and from page 54, 53, my lord, are all emails. My lord, they say that they are, my lord, facing banking issues and they are not someone who want to run away. Payments will be made. My lord, if I may place page 54, my lord, they say, dear Vishwajit, my lord, this is sent from Paramount. We have been facing some banking issues for last few weeks, due to which our funds are stuck. The same has been made known to you as well. We are trying to have it sorted ASAP. Hopefully within next week, we should have some information with proper dates to pass on to you. Understandably, your payments are stuck, but be rest assured, all will be made. Thank you for your cooperation. My lord, page 55. This is an email dated 21st November, again sent by the defendant. Lord, they say, dear Mr. Das, our payments are genuinely stuck and there is no two ways about it. As expressed in our email from 17 November, it is clearly mentioned, well, that is the earlier email that I had showed your lordship, 17 November. It is clearly mentioned we will advise date shortly. Even after the email, we had a conversation on Saturday 18th and you have been calling up today, Monday, ever since. Our commitments have failed. as the bank work is taking much longer time than normal to process and be resolved. Once the bank issue is resolved, payments will start rolling. Well, then they go on to say, I do not want to give you any specific dates at the moment, as I don't have any, but we are sure this will get resolved soon. The first payment of 5 lakhs will be paid immediately. Checks will be issued. My lord, this goes on. My lord, emails, they continue to, my lord, acknowledge. My lord, till page 62 are, my lord, emails where they say they are facing banking issues and payments will be made. But since nothing was paid, my lord, we sent a demand notice, my lord, a legal notice at page 63. My lord, I am not placing it before your lordship. My lord, page 65 is their email again.
Yes.
My lord, 26th April 2023. We are trying our best to clear the checks lying with you in the next coming days and will inform you of the exact date shortly. As far as balance checks are concerned, we will issue them at our earliest, and we will think it will be better if checks with you are cleared first. This is the reply to the legal notice. Thereafter, my lord, there is another email dated June 16, 2023 at page 66 on similar lines, my lord. Banking issues, payments will be cleared shortly. Now, my lord, at page 67, my lord, these were, my lord, general acknowledgements that payments were made, is to be made. My lord, page 67 is an email where they specifically admit a sum of money is due to me. They say, as at 31st March 2023, our outstanding balance is 19,05,720.94 as per our account without TDS deduction. This is sent from Paramount to me. Now, my lord, checks were handed over. Your lordship will see in that email. My lord, page 68, my lord, 4 checks were handed over. My lord, 2 checks were for rupees 2.5 lakhs each, one for rupees 4,90,000 and one for rupees 3.87 lakhs. But all these checks were dishonored. My lord, the intimation sent by the bank to me is at page 68, my lord, which show that, my lord, the checks were not honored. It shows, my lord, exceeds arrangement. Lordship?
68.
Yes, your lordship. 68, annexure I. My lord, this is the first check for 2,50,000. My lord, it says exceeds arrangement. My lord, page 69 is another check for 2,50,000, which also says exceeds arrangement.
Yes.
My lord, at page 70, the 4,90,000 check. My lord, it says payment stopped. And my lord, at page 71 is the other check, which also says, my lord, payment stopped. So no checks were, my lord, honored.
Then,
now, my lord, we sent a notice under section 138 of the Negotiable Instruments Act, my lord, at page 72, annexure J, 2nd June 2023. We say you make payment of the invoices of the checks, otherwise we'll initiate proceedings against you. In reply, my lord, at page 77, my lord, they admit for the last 8 to 10 months, we have had no operations at all. So no matter whatever we say will go against us. We are of the opinion it would not make sense to start legal proceedings as we are not cheats and are committed to pay the outstanding and clear them ASAP. We had plans of making payment in parts, but it did not go the way we planned because of the banking issues, which left us completely paralyzed for the past 9 to 10 months. We had to clear the mess created by them before we can resume. We have had come positive meetings in the last few days and weeks, and we are hopeful of the outcome. Understandably, you have waited long enough, and we are sure it's just a question of a short time before we can see the positive, clear intent as well, and be rest assured all will be paid. My lord, page 78, my lord, they say that they'll start making payments from 15 September, which they have not done.
Yes.
Yes, your lordship, at page 79, my lord, is an email dated 15 September 2023 sent by the defendant to the plaintiff. My lord, they forward a ledger. My lord, the ledger is at page 80. My lord, this is a ledger prepared by them. My lord, it bears their stamp and signature of the director.
Yes.
My lord, it shows, my lord, closing balance, my lord, 18,67,606.13 is due. Now, my lord, they have shown TDS of rupees 38,000. My lord, the last entry, that is 31st March 2023, my lord, which they have not deposited. So, my lord, the 19,05,000 acknowledgement in the email, my lord, that stands. No TDS was deposited. My lord, at page 81 in November 2023, my lord, they say that on and from December, payments will start rolling since we have waited. We should give them a chance.
Yes. Right.
My lord, they again gave checks at pages 82. My lord, this is my lord, the defendant is.
Senior is on the way, kindly.
Let the senior be remain there. Yes.
Yes, your lordship, at page 82, my lord, this is the second time they give us the checks. My lord, there were 3 checks. My lord, they have also been, my lord, dishonored. At page 83 onwards, my lord, it shows account blocked. Lord, this has been the conduct.
Yes.
Yes. Lord, thereafter, we have instituted proceedings under section 138. Now, my lord, in their opposition, my lord, they have taken twofold points. Lord, first is that my bills were inflated and they were to be discussed, and then sum was to be arrived at. Number one. Number two, they say, my lord, I am claiming sums which are more than what is payable to me. My lord, this is incorrect. Lord, what had happened after, my lord, we had filed the suit, my lord, they made a payment. My lord, we issued an email. We said that since we have approached court, we are not in a position to accept this payment. If your lordship kindly takes the opposition once, my lord, I'll show your lordship the email. My lord, at page 42 of the opposition. Yes, your lordship. This is an email, my lord, which has been sent on 11 July 2024. Please take note that the company has transferred a sum of rupees 47,013.3.
When you file the suit?
Yes, your lordship. My lord, it was filed in May 2024. I'm told.
May 2024,
your lordship. Lord, after filing, my lord, they, my lord, make a payment of rupees 47,000. Now, my lord, their contention that, my lord, the bills were inflated, etc.
So you accepted this?
No, my lord. My lord, we have, my lord, I'll show. If your lordship takes the reply, my lord, we have returned the sums. My lord, we have returned the sums.
Why?
My lord, since we had approached your lordship, my lord, that is why we have not accepted. My lord, my claim was around, my lord, 19 lakhs, more than 19 lakhs, principal claim. But they had only, my lord, given payment in respect of 2 invoices.
Correct.
Now, my lord, their contention that the amounts in the invoices were not correct and they were to be reconciled, my lord, is negated by their conduct inasmuch as, my lord, they pay the exact sum, my lord, which is due on account of 2 invoices. So that point goes. My lord, otherwise, they would not have made payment. They could have made a, my lord, part payment of some sort. But these were exact sums which were due for 2 invoices. Yes. My lord, will also see, my lord, page 44 of the opposition. They have annexed the ledger. So this is a further acknowledgement.
Page?
My lord, page 44 of the opposition.
No, pagination.
Sorry, my lord. My lord, the opposition, my lord, the second last page.
Yes.
My lord, my copy is, my lord, paginated. Yes.
Closing balance 9 lakh,
Yes.
19
Now they reverse the TDS, which they have not deposited. My lord, in the earlier ledger that had been forwarded to us, that is not there. So therefore, the outstanding dues are to the extent of rupees 19 lakh 05. This is their own acknowledgement. And my lord, they admit that, my lord, the bank had taken steps. They had no business, which is why no payment could be made. My lord, if your lordship kindly takes paragraph O at page 5 of the opposition, my lord, they have, my lord, repeatedly they have said that it is on account of the bank and the recovery action that they could not make payment.
Paragraph O.
Yes, your lordship.
Okay.
At page 5 of the opposition, my lord. Yes. But they say the defendant company has regular banking credits limits with Axis Bank. Unfortunately, banking authority created huge pressure upon defendant company, realized their whole dues within a short period of time. And such action was taken by Axis Bank authority without any prior intimation to the defendant, leaving the defendant with no choice but to stop the operation of the defendant company since the month of December 2022. Resultantly, defendant company went through tremendous paucity of working capital. It is admitted again in the opposition.
Yes. Then?
Yes. Your lordship, the payment that was made after filing of the suit, my lord, we have returned that. My lord, in my reply, my lord, I have annexed emails, my lord, at page 23. Yes. But this is their email, my lord, that is part of the opposition.
Yes.
At page 23, annexure B, my lord, we have replied.
Yes.
My lord, we have replied at page 24. We say that please be informed that the matter is sub judice and pending in court of law. We will not be able to accept payment made by you and return the fund transferred to you. But there is a further email at page 25, which has been issued by us, my lord, where we have said, please refrain from making further payments. Lord, we had asked for bank details, my lord, which they had not provided. Ultimately, my lord, at page 29, your lordship will find that we have addressed a letter, my lord, whereby we have returned.
Yes. Then?
Yes, my lord, we have said we are hereby returning a sum of rupees 47,013, which was transferred by you as the matter is pending before the Honorable High Court. Lord, at page 30, my lord, it will show that it was sent to them. But in the opposition, my lord, they do not disclose that these payments were, my lord, returned to them, or we had issued emails.
They have taken the stand, they have paid the amount.
My lord?
This amount was paid, they have not taken the stand.
Yes, they have taken, but they have not, my lord, disclosed that we have returned. My lord, one thing I must point out to your lordship, my lord, at page 11, my claim amount is, my lord, 19,06,916. My lord, their admitted sum due is, my lord, 19,05,000.
1,000 difference.
My lord, there is a difference of 1,000, sum of rupees 1,000 on account of, my lord, I am instructed on account of TDS, which whether they have deposited, not deposited. My lord, I will restrict my prayer to the quantum of sum that has been acknowledged in the email and the ledger. My lord, these are my humble submissions. Lord, if they cite any judgments, my lord, I shall. My lord, I shall rely on, my lord, judgments. I am not citing them. Your lordship is aware of.
What about the interest?
Yes, yes. interest we have claimed at, my lord, 18%. Now, if your lordship takes our invoices, my lord, on and from page 31, at page 32, my lord, from the bottom, if your lordship will see total charges, lord, at page 32, total charges below that, please pay due as per agreed date to avoid delay penalty. Interest will be levied at 18% per annum from the due date till the date of. Lord, this is there in every. Lord, my lord, they have accepted and not disputed this position.
Yes.
My lord,
That's all.
humble submission.
That's all.
Yes.
The senior is on the way, Your Honor.
Let it be done the
He's on the Sialda Code, Your Lordship.
Let it be in the Salda Court, City Court. There are so many court, Alipur Court. I don't know further courts.
Your Honor, actually, the senior had told me to take the pay for the note today, Your Lordship.
50,000. Deposit 50,000 for 1 week. Ask your senior is ready to deposit 50,000. I will grant 1 week time. If not, I am passing the judgment here in now.
Lord, in the meantime, if I may place my lord Uttam Singh Duggal, the lordship is aware. Lord, paragraph 12. At page 7, my lord. As to the object of Order 12, Rule 6, we need not say anything more than what the legislature itself has said when the said provision came to be amended. In the objects and reasons set out while amending the said rule, it is stated that where a claim is admitted, the court has jurisdiction to enter a judgment for the plaintiff and to pass a decree on an admitted claim. The object of the rule is to enable the party to obtain a speedy judgment, at least to the extent of the relief to which, according to the admission of the defendant, the plaintiff is entitled.
ये मनोदर ये मैटर कल भी था क्या हुआ नहीं था एडजॉर्नमेंट यस कहाँ है वो भाग गया
Just senior phone पूछे ना first.
Yes.
Sir, kindly 15 minutes. It's on the base. 15 minutes, sir.
Asu.
Number 8. This matter, I am for the plaintiff, my lord. But this is a suit for realization of sum of rupees 6 crores. Then that advance to a defendant. Defendant never appeared before this court, my lord. I'm paying some accommodation, my lord, subject to lordship pressure. Because we wanted to attach a property which could not, because the defendant was under behind the bar for 6 years. Now he has been
You are
released
for
on
the
bail.
plaintiff?
Yes, I am for the plaintiff. So, my lord, I want to procure some properties belonging to him to attach that, because order has already passed.
What order?
That to realize this amount.
Decree passed?
Not degree, but to realize this. Degree has not yet been passed. We shall place for the degree.
What is the application?
This application for
GA4?
GA4 for realization of the amount. Attachment of a property which belongs to
Shanti Surana, Prabha Surana.
Yes, Shanti Surana. And whole family was behind the bar.
So what remains in outside?
But his wife, daughter, everybody was inside. Now they have been released on bail. So can you give me some time, Mala, to get the list of properties for attachment?
Before
before I shall place for the degree, my lord.
Before getting the list, before getting on details, you file the application for receiver. You file the application for receiver. Now you file the details of the debt.
But unless I give the details of the property.
Why you file the GF without the details?
But that attachment was made by the bank and they have realized the money. We have given any
Naturally, bank will attach.
Yes.
Because he is the defaulter.
That is true, my lord. Bank has got.
What you want?
For 2 weeks time, maybe again.
As per the prayer made by the counsel for the plaintiff, the case adjourned for 2 weeks. Please the matter on 29th of November 2024.
Deeply appraised.
Next.
Item number 10.
Item number 10, Lordship, I am appearing on behalf of the plaintiff.
I oppose the applications.
My lord, what has happened, my lord, Lordship may kindly recollect when this matter was taken up earlier. The main interrogatory at GA4, which was reserved by the coordinate bench on April 24, 2023. Now, in view of the judgment not yet being pronounced in GA4, there were other applications which were filed earlier by my client and also by my learned friend, Mr. Basu. Now, both these, my application and Mr. Basu's application could not be taken up because of the non-pronouncement of the order in GA4. That is a difficulty we are facing.
What is the GA4?
GA4 was the second round of interrogatory application which was filed by the plaintiff after the matter went up to the Honorable Supreme Court.
Suit essentially for damages. Now, Mullah, there was an agreement of December 2017 that both the parties entered into, that he will run the tea garden and Mullah, he will pay me for the tea that is cultivated in the garden. But Mullah, there was a negative covenant that I will only sell the tea to him. Mullah, in 2021, he filed GA1 for enforcement of the negative covenant in the agreement in a suit essentially for damages. He did not get any order. His application was dismissed on the ground that there was fundamental breach of contract. GA1 was dismissed. Now, Mulad, he goes up in appeal. Thereafter, Mulad, he gets an order that a receiver will collect the tea, will sell the tea, and thereafter keep the sale proceeds in an interest-bearing account. Mulad, that the receiver has done. Now, Mulad, the matter goes up to Supreme Court. Now, Mulad, Supreme Court passes an order in 2023 setting aside all the orders and remanding the matter back. Now, Mulad, after remand, in January 2023, Mulad, they filed GA4, which was a comprehensive application renewing their prayer for enforcement of negative covenant. Mulad, if GA4 stays, then which is identical to GA1, then GA1 goes because GA4 is comprehensive and more wider than GA1 is concerned. So GA1 can be dismissed.
GA4, what has happened?
No, kindly, when the GA4 is the one.
Affidavits complete, hearing complete in 2023, but my lord, unfortunately, my lord, the judgment wasn't delivered. But thereafter, my lord, it is.
Lordship, I was humbly submitting, kindly keep it in the next monthly list. My lord, we are in a very, Lordship knows as a litigant or advocate, my lord, and the order is pending, my lord, we are in a very difficult situation. I hope Mr. Basu will be feeling the same. So, my lord, to avoid any
the same way he is feeling.
My lord, I am feeling so. Lordship, kindly keep it in the next monthly list or in. Malala, we are in a very difficult catch-22 situation.
Mr. Basu is taking the advantage.
No, Malala, this suit is not only for damage, it's for specific performance also. So, Malala, to either keep in the next monthly list or in January monthly list, Malala, we are trying to see how to get the judgment activated. That is the only thing which is left, Malala. But kindly do not put it in the words. Kindly keep it in January or December monthly list, Malala.
I will not object to the prayer, but because essentially all are his applications.
So-and-so appearing for the plaintiff, so-and-so appearing for the defendant. The counsel for the plaintiff submit that the coordinate bench of this court has already heard the matter being GA4 of 2023 and reserved for order. In view of the above, the case is adjourned for.
Lordship, only one thing. Lordship may kindly give the date in the order. It will be helpful. April 24, 2023. Maybe our fortune will change. You never know.
Your lordship has to hear it out. Because the post change of determination, everything is now before your lordship. And it was.
No, but
No, unless GF4, there is.
Judgment reserved, this court cannot. If judgment reserved,
the process has to be followed.
Unless it is released. Unless if the judgment reserved, judgment passed, no problem. If not passed, if it is released, then the rehearing.
Yeah, then automatically we can come. That is the problem.
Let the matter appear in the combined monthly list of December 2024.
Grateful.
Great.
Matter number 11.
My lord, defendant number 3 has filed an appeal which is pending before the division bench of Honorable Justice Apurva Shomen Sen and Honorable Justice Apurva Sinade. I was praying, my lord, if this suit be kept adjourned till the disposal of the appeal.
Against which order?
My lord, I beg your pardon, lordship, but I am not carrying the brief mistakenly.
You are for the?
I am for the petitioner.
Plaintiff?
Plaintiff. Suit. Plaintiff.
What order is passed? You don't know.
No, your lordship.
Which is under challenge? So-and-so appearing for the plaintiff. None appears on behalf of the defendants. Counsel for the plaintiff submitted the defendant number 3.
Defendant number 3 has filed the appeal.
Defendant number 3 has preferred an appeal against the order passed by this court, and the same is pending for the adjudication. You are for the?
Defendant number 3, my lord.
Which order you are challenged?
My lord, the order by which the terms of settlement has been decree has been passed in accordance with the terms of settlement between plaintiff and defendant number 1 and 2, and we have preferred appeal against that order.
So-and-so against passing, pending before the appellate court. In view of the above, the case is adjourned. Let the matter appear in the combined monthly list of December 2024.
Grateful, your lordship.
3, huh? Plaintiff and defendant number 3. Yes.
12.
Item number 12, my lord. For the defendant, my lord. Now, this is a change brief, my lord. We are yet to file the wakalatnama, my lord. We are taking steps, my lord. I am praying for 2 weeks' time, my lord.
For the defendant number?
I appear for the defendant number 1, my lord.
You are for the plaintiff?
Yes, my lord.
Lord, we filed a written
We are yet
statement.
to file the wakalatnama, my lord.
What is the GA1? GA2?
My lord, I have yet to receive the briefs, my lord.
You have not received the brief?
No, my lord.
You have not received the wakalatnama and you are appearing?
My lord, we have received the wakalatnama with no objection. It is yet to file, my lord.
Why not filed?
My lord, we have taken steps, my lord. We are in process, my lord.
Lord, GA2 appears to be an application of Order 7, Rule 11, my lord.
Okay. Rejection of plaint.
Rejection of claim.
Filed by defendant number 1, defendant number 2. You have filed.
Yes, yes, my lord. This is my application, sir. I apologize. This is my application and order 711.
Defendant number 2.
No, my
Defendant
lord.
number 2.
Defendant number 1.
I am the defendant number 2.
Dad, I'm confused now. Defendant number 2 actually. For the defendant number, I stand correct. For the defendant number 2.
So, you are not filed.
No, no.
Who is appearing?
No, no,
for
my
the-
lord. This is my application.
But
I am appearing for the defendant number 2, my lord.
You are
It's
appearing
not
for-
for 1. For 2. I stand correct.
So he is asking time. It is here.
Even.
So and so appearing for the plaintiff. So and so appearing for the defendant.
In the meanwhile, my lord, could I pray? I mean, I apologize for the interjection. Meanwhile, lordship could direct them to file their opposition to this if they want to, my lord.
They have
This
not
would-
filed.
May I
Let
first
them
open the
complete the
plea?
process then. So and so appearing for the plaintiff. So and so appearing for the defendant number 2. Counsel for the plaintiff submit that this is the change brief and required to take instruction and to file wakalatnama. He has obtained the wakalatnama from the earlier counsel but has not been filed in the department. Accordingly, he prays for time. In view of the submission made by the counsel for the plaintiff, the case adjourned for 2 weeks. Let the matter appear on 22nd November 2020. Next. Number 30. Shipping line. None appears on behalf of either of the parties. No accommodation is sought for. It is fine from the record the matter was listed on 27th of August 2024. And on the same date, the counsel for the plaintiff has submitted before this court that the plaintiff intend to engage some other advocate. And as per the prayer made by the counsel for the plaintiff, the case was adjourned till 24th of September 2024. Since then, none appears on behalf of the plaintiff. Today also, when the matter is called, none appears on behalf of the plaintiff. No accommodation is sought for. In view of the above, CS Com 258 of 2024 is dismissed for default. Consequently, all pending applications are also dismissed. Yes. Call the password matter. Item number 7.
Lordship, in this matter, I am appearing on behalf of the defendant. In this matter, I am led by Partha Chakraborty. His father has died.
Huh?
His father has
Whose
died.
father?
Partha Chakraborty,
Whose father?
conducting advocate. His father has
He stated that he is in Salda court.
I am in Shianda.
So you are advocate on record.
Yes, I am
So?
advocate on record, but I am late by.
When his father died?
Father died just on the reopening of day. Just seeking an accommodation for.
Why you not asked for the adjournment on that ground when the case was called?
Yesterday also
Yesterday also the matter was he stated that tomorrow.
Yes, Your Lordship,
So?
I seek apology, but I am nothing to do.
I will inquire from the police whether
I'm genuinely his father. I can
why it
produce the
has
case
why
certificate
it has not been submitted yesterday, why it has not been submitted when the matter is called today at the first they have concluded their argument.
Yes, Your Lordship, I was looking for other alternatives so that we can conduct the matter, but I'm just seeking accommodation for 2 days time. I will come back with the proper instruction.
So and so appearing for the plaintiff, so and so appearing for the defendant. Police. A plaintiff has filed the present application being GA Com of 2024, praying for judgment on admission. Judgment upon admission. Police. Counsel for the plaintiff has concluded his argument. Police. Counsel for the defendant submit that the father, due to the death of the father of the appearing counsel for the defendant is not in a position to appear before this court and prays for adjournment. In view of the circumstances, the case is adjourned. Let the matter appear on
We can come back on Monday.
12th.
12th
12th under the same heading as part heard.
Yes, Lord. Great, great. Grateful. এটাই তো বলে দিলে হয়ে যেত, এত সময় লাগবে না, বেকার জজের সময় নষ্ট করতে।
None appears on behalf of either of the parties. No accommodation is sought for. It is fine from the record. The matter was listed on 30th March 2022 and on the prayer made by the counsel for the plaintiff, the case was adjourned. Today also when the matter is called, none appears on behalf of the plaintiff. No accommodation is sought for. Accordingly, this court has no other option but to dismiss the suit for default. CS number 68 of 20. Hey, it is commercial. नंबर पता है CS सूट लिस्टेड है क्या, ये एप्लीकेशन है, सूट है, कहाँ सूट? CS नंबर 60 इज अ कमर्शियल नंबर दिया, CS com 259 of 2024 within bracket old CS number 68 of 2021 is dismissed for default. Consequently, all pending application is also dismissed for default. Interim order, if any, stand vacated. Next. None appears on behalf of either of the parties. No accommodation is sought for. It is fine from the record the matter was listed on 9th of February 2023, but on the said date also, even on the second call, none appears on behalf of either of the parties. Accordingly, the case was adjourned. Today, when the matter is called, none appears. No accommodation is sought for. In view of the above, CS number 260, CS com 260, CS 87 of 2021 is dismissed for default. Interim order, if any, stand vacated. Consequently, all conducted applications are also dismissed for default. Next.
Item number 16.
None appears on behalf of other parties. No accommodation is sought for. CS number 267. CS comma 267 of 2024 within bracket old CS number 87 of 2021. 87? No. 267 2024 old CS number 92 of 2021 is dismissed for default. Interim order, if any, stand vacated. Consequently, all connected applications also dismissed for default. Next.
17.
Not 77, 17. Again, it will be difficult. So, शुरू से down है. Not today. But matter is listed. They could have been appeared. Next.
I am for the plaintiff in this matter, Lordship. Lordship, in this matter, two GAs are appearing in this matter, GA1 and GA6. GA1 is filed on behalf of the plaintiff. That is for direction upon the defendant to furnish security and attachment of the properties. In this matter, the defendant has also filed an application where an order passed by this court seeking a direction from the GST department to file a report before this court whether any GST has been paid by the defendant on account of good and sold and delivered to the plaintiff. The GST department has filed a report to the effect that no GST has been paid. Now, the defendant has filed an application being GA number 3, taking exception to that report. So that application was dismissed for default. For that, they have filed a restoration application. The first restoration application was dismissed. Now, the second restoration application, that is GA6, which is appearing in the list today. Now, the defendant is today, they also are not represented. Lordship, if Lordship may kindly see the last order, that is 10th June 2024.
You are for the plaintiff?
I am for the plaintiff. This is their second restoration application.
GA3 record has come. Yes, but nobody is there. Server is not working. Who is appearing? Mr. Bandopati.
Mr. Purush Bandopati has appeared on the occasion in this matter.
Yes. Other side is not here.
Well, they are never here.
They will not come.
Conveniently not here. Well, this matter has a checkered past. I'll tell you, Lordship. Well, simpliciter suit for recovery of money. In the suit, we filed an interrogatory application. They were defending the interrogatory application. One of their principal defense in the interrogatory stage was that, well, this was in respect of goods sold and delivered, money not paid. What was sold was gold jewelry. Now, my lord, they took a defense in their opposition to the interrogatory application that they had, instead of the money given, they had given gold to us. It was just a bald allegation. Now, the previous the coordinate bench said that if you've given gold, that means you sold gold to them. So there'll be an issue of GST, you must have paid GST.
Naturally.
So there was nothing, because now GST, you have to file GSTR1 if you are the selling dealer. That means I become the purchasing dealer. All this happened, my lord. Orders were passed from time to time. The state authorities, the GST authorities, were directed to file reports. 3 reports have been filed till date. 3 reports are on record. They have taken exception to the report filed by the GST authorities. Reply affidavit has been complete. Then they file an application asking for application for dismissal. They had filed an application taking exception to the report filed by the state authorities. Application dismissed. Restoration dismissed. One other restoration filed, they don't move it. So this is the situation. So I need, admittedly, this is an undisputed debt, because the moment you say that instead of the money I have given you gold, so that means the debt is undisputed. That is why you gave me gold. So your gold giving has now been proved to be a completely false case. So my lord, I need some protection. That's all. So everything is on record. So this is, I want a protection so far as the claim is concerned. Because if they sell and their conduct is such, and my lord, I come well within the purview of Order 38 Rule 5. So because their conduct is such, even if I get a decree, your lordship, hypothetically, if I get a decree, I'll have nothing to execute the decree. It will become a paper decree.
Today anything is there with them. Today anything is there with them.
Well, there's not, they have nothing apart from the fact that there are amount they are disposing of assets, because the conduct of this, apparently this false conduct has made us more alarmed. We've become more conscious after this. Well, there's one thing to say that my claim is disputed, but it is another thing to set up a false defense.
That is different.
Completely different. But I am just asking for an order requiring them to furnish security.
But
At least let them furnish show cause as to why they will not furnish security.
GA6?
That would be GA1, my lord.
No, GA6 is the
restoration.
That is the restoration. Restoration of a restoration.
delay in taking present. Yes. What is the application? GA1?
Yes, madam. No, my application is GA1. Their application is, the last application that they have filed is GA6, which is seeking to recall the order by which GA3 was dismissed.
Yes. GA3 is?
GA3 is their application to take exception to the report filed by the state GST authorities. Because the GST authorities said that there has been no sale.
Exception to be taken to the report of the Deputy Commissioner of Revenue Sales Tax. Yes. So that has gone. So now the J6 is to be dismissed now.
Yes.
Nobody is appearing.
And this is not the first time. Order gulo dao na. This is not the first time. This is every time it comes up for hearing, this is what they do. I have got a list of orders. If my lord will want to peruse, I've got
I am dismissing GA6.
My lord.
And I will fix the GA1.
Very well. Very well. Very well.
So appearing for the plaintiff. None appears on behalf of the defendant. Defendant has filed an application being GA Form 6 of 2024, praying for recalling of the order passed by this court dated 19th February 2024, wherein GA3 of 2023 filed in CS Com 279 of 2024 is dismissed for default. Today, when the application was taken up for hearing, none appears on behalf of the defendant. No accommodation is sought for. Even the court has waited for long time, but none appears on behalf of the defendant to represent the defendant to move the application being GA6 of 2024. Accordingly, GA Com 6 of 2024 is dismissed for default. Learned counsel for the plaintiff submit that the plaintiff has filed an application being GA1 of 2024.
File 20 GA1
21 of
2021.
2021 praying for interim order. Let the same be fixed for hearing on 12th November.
File.
Under the heading Adjournment.
13th. 14 or 30, any day
13,
after
14,
the
then 18th.
18th
November.
18th.
Next.
Is your lordship fixing the time?
I am taking regular.
Very well. That's better. That is better. My lord, may I just pray for one indulgence? While dismissing, would it be your lordship pleasure to record a previous order by which GA3 was once again previously dismissed, 19 February 2024? Because once they make a restoration once again, because there was a previous dismissal as well. If your lordship will kindly take once page 18 of that application.
It is also fine from the record. It is also fine from the record. GA3 was earlier. GA3 was also dismissed earlier. Dismissed for default earlier
by an order of 19th February 2024.
By an order dated 19th February 2024.
The restoration.
But no. 19th February, this was dismissed.
February to the recall charge. আর আগে একবার ডিসমিস হয়েছিল না? সেটা কোথায়? Well, he is asking for recalling of 19th
February.
Yes. There was a previous item. না ওটা দেয়নি। তোমার কাছে আছে ওটা? তার আগে
No such order.
Well, 6 September 23, I stand corrected. 6 September 23, GA3 was previously dismissed for default.
2023, and subsequently the same was restored. And again, this said GA3 was dismissed by an order dated 19 February 2020. Yes, again the same was restored, and again the same was dismissed by an order dated 19 February 2020. This court find that the plaintiff is and the defendant is not interested to proceed with the matter, only to kill the time and to harass the defendant, has filed the application accordingly. GA6 is dismissed for default.
Great.
Next.
But before your lordship takes up the next matter, the previous matter, item 17, the board was not working, my lord. I could not reach, my lord. If your lordship has dismissed it,
not working.
The outside board is not working.
Board was not working.
My lord will kindly
not today.
Oh, if it's not today, my lord, I'll come back. Great.
Yes, next. Not legal. Not legal.
Item number 19.
Item number 19, my lord.
Yes.
I am for the plaintiff, my lord. Lord, this is also a change brief, my lord. We are yet to receive the wakalatnama, my lord.
Who is for the other side?
That we
I'm appearing for the defendant.
Plaintiff.
Defendant number 2.
Defendant number 2.
You are for?
Who is?
Petitioner.
Sorry
What is your submission?
Your Lordship, this matter was lastly called on 3rd of April when their IA1 was dismissed because they were not appearing.
on instruction, I am submitting, my lord, that there are certain deliberation between the plaintiff and the erstwhile advocate record, my lord. They are not giving the no objection on the wakalatnama, my lord. I think that will be resolved sooner, my lord. Otherwise, my lord, if my lord grants us the leave, my lord.
Yes, 4th July, there is an order of master. Defendant number 2, they could not file the no objection wakalatnama till date.
My lord, then, my lord,
You are appearing for whom?
Plaintiff, my lord.
So,
if
what
leave
do you
be
want
granted,
now?
my lord.
Huh?
If leave be granted to file the fresh wakalatnama without
Sons appearing
no
for the
objection.
plaintiff, sons appearing for the defendant number 2.
Your Lordship.
Defendant number 2. Counsel for the plaintiff. Press submit that. This is a change brief, and he requests to file wakalatnama, and accordingly prays for time to file fresh wakalatnama after obtaining no objection.
My lord, if without no objection, my lord, if can be
to file fresh wakalatnama. In view of the submission made by the counsel for the plaintiff, the case adjourned. Let the matter appear on 22nd November 2020. Yes. Next.
Another 20 and another 52 and 53 of the commercial.
Yes.
My lord, I'll just, my lord, very briefly, my lord, recap, my lord. There's the matter. My lord, two things. My lord, Mr. Chinoy had handed over a list of dates. Your lordship has that. And my lord, I had handed over a list of dates as well. Now, my lord, before I, my lord, recap, my lord, lordship recalls, my lord, that there were really, my lord, 6 points, my lord, which were argued by Mr. Chinoy. My lord, on the basis of which the argument was, my lord, that the award should be set aside.
Yes.
My lord, the first point which was argued by Mr. Chinoy was that, my lord, a matter has been adjudicated upon which had not, my lord, which was not part of, my lord, the, my lord, submission. Second, my lord, what was really required to be decided had not been decided. So, my lord, these are, my lord, one is beyond the scope of the reference, and, my lord, what was the scope of the reference has not been decided. Third point was, my lord, that, my lord, the decision goes beyond the pleadings because, my lord, the statement of claim and the statement of defense do not talk about, my lord, the orders of court, but, my lord, the award has been passed on the basis that the contract had been modified, my lord, by the consent orders. Then, my lord, there is, my lord, a perverse interpretation, my lord, that is, my lord, the fourth of clause 3F of the order dated 20th of May 2022. Fifth, my lord, is, my lord, that by, my lord, allowing, my lord, a letter of credit, my lord, which was, my lord, termed by the arbitral tribunal as UPAS, my lord, it is, my lord, completely contrary to the terms of the contract. And, my lord, therefore, my lord, there is a unilateral, my lord, alteration to the terms of the contract, or contract which has not been agreed to between the parties has, my lord, been given effect. And lastly, my lord, that the award itself, my lord, is inconsistent, unintelligible, and there is an error apparent on the face of the record. Because, my lord, the arbitral tribunal having held that, my lord, the respondent should get damages of 21.98 lakhs, my lord, has, my lord, awarded damages of, my lord, 5.60 crores. And, my lord, despite, my lord, the respondent giving up the claim of 21.98 lakhs, my lord, the arbitral tribunal came to a finding that the respondent was entitled to, my lord, 21.98 lakhs. My lord, this was, my lord, really the arguments, my lord, which had been made, my lord, by Mr. Chinoy.
Yes.
Now, my lord, in response, my lord, I have covered, my lord, partly. The first point which I have covered, my lord, is, my lord, that, my lord, the issue, my lord, number 3, which was decided by the learned arbitral tribunal, was not beyond the scope of the reference. My lord, that's the first point which I argued. My lord, I had drawn your lordship's attention, my lord, to the arbitration clause in the agreement, that it was of the widest amplitude. My lord, I had cited, my lord, Renu Sagar's case,
Yes.
my lord, apropos, my lord, this, my lord, 1994 Supreme Court.
Yes.
Then, my lord, the issues, my lord, which had been framed, including issue number 3, my lord, were, my lord, issues which were framed at the instance of the parties at the third sitting of the arbitral tribunal dated 8th August 2022.
Correct.
And, my lord, this was after considering the suggestions and, my lord, arguments of the parties. So it cannot, my lord, be said, my lord, that, my lord, this issue number 3, my lord, was not, my lord, within the, my lord, scope of, my lord, the reference. In fact, my lord, my lord, statement of claim, my lord, which I had also drawn your lordship's attention to, my lord, volume 3, pages 361, 362, para 37. My lord, shows, my lord, that, my lord, the claim, my lord, arises out of, my lord, breach of, my lord, 2 consent orders by, my lord, the respondent. So, my lord, this was the case of the, my lord, claimant, my lord, the petition, my lord, the claimant, my lord, itself, my lord, then, my lord, in the notes of arguments, my lord, the claimant itself has extensively addressed the issue of, my lord, breach of the 2 consent orders. And, my lord, lastly, my lord, I submitted, my lord, before your lordships, that, my lord, if, my lord, the disputes raised are within the ken of the arbitration agreement, I'm using that language, or disputes submitted to arbitration, they cannot be said to be disputes which are not contemplated or fall beyond, my lord, the scope of the arbitration agreement. In this regard, I relied on Sangyong's case, 2019 15 SEC 131 para 58.
Yes.
Now, my lord, apropos, my lord, issue numbers 1 and 2, my lord, not being decided, and only issue number 3, my lord, having been decided,
Yes.
I had, my lord, submitted to your lordships, my lord, that, my lord, this, my lord, merely because, my lord, a particular issue, my lord, had not been decided, cannot be a ground, my lord, for setting aside of the arbitral award.
Correct.
My lord, I drawn your lordship's attention, my lord, to Order 14, Rule 2 and Order 20, Rule 5.
Yes.
That, my lord, if one of the issues, my lord, disposes of the entire case, my lord, then, my lord, the other issues, my lord, need not be decided on. And thirdly, in any view of the matter, the arbitral tribunal having held that, my lord, the consent orders merely, my lord, did not modify, my lord, the agreement, but only provided for the manner of its performance. My lord, it has, my lord, then, my lord, deciding, my lord, that the third consent order had been breached, my lord, by, my lord, the claimant itself, my lord, had actually, my lord, decided all, my lord, the issues 1, 2, and 3. So, my lord, this is, my lord, what I had, my lord, submitted before your lordships. And, my lord, the learned arbitrator, in fact, my lord, I had shown your lordships, my lord, para 22 to 27 of the award. My lord, that section 63 of the Indian Contract Act, my lord, had been pressed into service because it's the manner of performance. Third, my lord, there was, my lord, no question of, my lord, any matter being decided, my lord, which was not in the pleading, because the learned arbitrator has not held that, my lord, the, my lord, consent orders modified the agreement. It, my lord, said, my lord, only manner of performance, which was section 63. In any event, what is important is this issue, my lord, was very much alive. Even if it was not in the pleading, my lord, arguments were made by both parties, my lord, on this issue. And therefore, my lord, as long as a party is not taken by surprise, my lord, the fact that it's not in the pleading, my lord, will make no difference. My lord, I had cited, my lord, cases, my lord, apropos, my lord, this, my lord, before your lordships. Then, my lord, the case of, my lord, any particular clause, my lord, of the agreement, my lord, of the consent order of 20th May, my lord, being misconstrued, my lord, is a matter of interpretation, where, my lord, the arbitral tribunal, my lord, has, my lord, complete, my lord, autonomy, so to say, my lord, to decide, unless it can be shown that something was completely absurd, which is, in my respectful submission, my lord, not, my lord, been established here.
Yes.
And last, my lord, and not the least, my lord, I had, my lord, then handed up the list of dates to your lordships, my lord. And here I'll just trouble your lordships with, my lord, 7 dates, my lord, just for recapping. My lord, your lordship has, my lord, that list of dates. My lord, 22nd, my lord, it's, my lord, the first and most important date, my lord, is, my lord, the date of the contract. That's the first date,
22nd February.
22nd February.
Correct.
Lordship will find, my lord, in the first page itself. My lord, kindly note this, my lord, I have underlined it. Delivery order was only to be issued after payments of balance amount. So, my lord, delivery, my lord, what is important is the contract all along contemplated that delivery is after payment is received. Now, my lord, kindly come to, my lord, the date of 25th April 2022. My lord, which is the fourth page, I think, my lord, of the list of dates.
Yes. 25th April.
Yes. My lord, this is, my lord, the date of the filing of the suit.
Yes.
And the prayers in the suit, my lord, I had praised. My lord, one is specific delivery of 10,000 metric tons, alternatively specific performance, and perpetual injunction restraining the respondent from dealing with. So, my lord, the prayer, my lord, in the suit was for enforcement, my lord, of the agreement of, my lord, 22nd February. And the interim order which was passed, my lord, by reason of, my lord, this prayer, in aid of this, my lord, is, my lord, a direction on the respondent, my lord, not to deal with the goods or create third-party rights or remove goods. So, my lord, the goods, my lord, were, my lord, stuck, my lord, by reason of, my lord, the interim order of 25th of April 2022. Now, my lord, the third important date, my lord, is, my lord, the appeal, my lord, which is filed. And, my lord, I have indicated the grounds, my lord, ground 10 and 11, that, my lord, the no prima facie case had been made out, and, my lord, the petitioner had failed to open a letter of credit as per the contract. And, my lord, in this, my lord, on 27th, my lord, the interdict on the entire goods was removed. It was only kept on 10,000 metric tons, and then, my lord, disposed of by a consent order of 28th April,
Yes.
which, my lord, really provided, again, kindly have a look at bullet point 3. The petitioner was required to make the balance payment of so-and-so through letter of credit in accordance with contract within 3 days of its finalization. And the petitioner was given the liberty to lift the 10,000 metric ton of low ash metallurgical coke after paying the balance amount. So, my lord, again, my lord, the agreement between the parties was, my lord, that you will only get delivery after, my lord, payment. And, my lord, the letter of credit, my lord, the payment has to be made 3 days after its finalization. Now, your lordship will find I have a NB, my lord, at page 6. Therefore, even by this order, payment had to be made within 3 days of opening letter of credit, and delivery was to be made only after receiving payment.
So this is clear.
My lord, yes. Now, my lord, again, my lord, the, my lord, petitioner, my lord, sent, my lord, certain letters of credit, which I had pointed out to your lordships, that on 30th April, that, my lord, they provided for, my lord, payment to be made 90 days from date of shipment, which was, my lord, contrary to the order dated 28th April. My lord, I've got on 30th April, the NB, your lordship has.
Yes, yes.
My lord, that, my lord, I have pointed out. Then, my lord, there is, my lord, a lot of toing and froing. And 6th of May, kindly come to at page 7. My lord, 2 draft letters of credit, my lord, were provided 6th May.
Yes.
And, my lord, what is important is both, my lord, the letters of credit provided for, my lord, delivery before payment, which is contrary, my lord, to the orders. That's what I wanted to, my lord, point out. Clause 46A, my lord, in one, and clause 46A in the other. My lord, both of them provided for delivery, my lord, after, my lord, before payments are made, because lorry receipts had to be given to them. And, my lord, the contemplated delivery in tranches, which was also, my lord, not provided for, my lord, in this. Now, kindly come to page 9, my lord, of that list of dates. My lord, a contempt petition and an application, my lord, for modification of 28th April were filed. My lord, that's 12th May and 17th May. And, my lord, again, my lord, 20th May 2022 was the other consent order. And kindly come to bullet point 4. The respondent undertook to deliver so and so immediately upon receiving balance consideration. So, my lord, bullet point 1 says would amend site LC to a usance upon a written request within 7 working days. Then, my lord, bullet point 3 would be discounted within 3 days. And, my lord, after, my lord, discounting, my lord, yes, so after receiving balance consideration, delivery, my lord, would be made.
Yes.
And, my lord, kindly take the last bullet point, which shows how wide, my lord, the reference was, that, my lord, all issues were left open to be raised. So, my lord, kindly see the NB here. Therefore, this order only contemplates a usance bill, usance payable at site, as the order provides only 3 days to the petitioner to discount. The notes of argument of petitioner would show that petitioner has argued breach of consent orders.
Yes.
Now, my lord, kindly turn to, my lord, page 12. 31st May 2022. My lord, 11 days, my lord, after passing of the consent order, my lord, the relief for specific performance, my lord, which was there in the suit is given up. 31st May. The petitioner by an email informed the respondent that it had decided to procure lamb coke from market and demanded refund of 4 crores 49 lakhs 55. Lordship has that, my lord?
Yes, yes.
Now, my lord, then, my lord, we, my lord, object. And what happens is 31st May, the last date on that page, my lord, section 17 application.
Yes.
Kindly see the praise, request of letter of credit to be discharged and bank guarantee to be discharged and direction upon the respondent to refund. Now, my lord, kindly see the 3 NBs, my lord. The prayers made by the petitioner previously were in aid of final relief. However, petitioner abandoned that prayer to pursue a claim for damages. Petitioner did not press for prayer B, seeking liberty to file an application for interim award. And, my lord, NB, petitioner averred in statement of claim that letter of credit automatically stood discharged. Accordingly, submission was restricted to discharge of bank guarantee, so and so. So, my lord, in effect, my lord, what was, my lord, the basis of the agreement, the basis of the suit, the basis of, my lord, the two consent orders of 28th April and 20th of May, my lord, were, my lord, being given up. And, my lord, kindly now turn to page 13. My lord, 22nd June 2022, petitioner filed a statement of claim seeking an award for 25 crores as pleaded, and on the alternative an inquiry, interim interest. And, my lord, NB, kindly see petitioner abandoned the prayer for specific performance. Then, my lord, the counter statements, etc., my lord, were, my lord, there. So, in effect, my lord, 2, my lord, important facts, my lord, which are relevant, because that's the basis of the award of damages to me. My lord, first is, my lord, that, my lord, all along, my lord, the agreement and the 2 consent orders, which provided for implementation of the agreement, contemplated, no matter what kind of letter of credit, that, my lord, I would receive, my lord, the goods need to be delivered by me only upon payment being made. This is, my lord, most important. Secondly, my lord, the suit as well as, my lord, the 2 consent orders were premised on the basis that, my lord, they were, my lord, going to, my lord, press for specific performance.
But that was amended.
That was, my lord, abandoned. Now, my lord, in this context, my lord, kindly come to paragraph 54, my lord, of the award, which I, my lord, need to, my lord, place before your lordships, my lord. This is, my lord, at page
788.
my lord, 816, my lord, I believe. My lord, the award, my lord, starts, my lord, at page of, my lord, this is of volume 6. Award starts at page. Yes, my lord, 703, my lord, volume 5.
Yes.
Whether you have them or don't have them, you just tell me you don't have. Now, my lord, 703 volume 5 to 834 volume 6, my lord, is the award.
Yes.
Now kindly come to, my lord, para 54. Because, my lord, what has been argued is that, my lord, this 5.60 crores could not have been awarded at all. Now kindly see para 54. After taking into consideration the materials on record showing the admitted rate of the goods in question, as would appear from the uncontroverted documents marked as GG, HH, II, JJ of the statement of defense, and also the consent order of the High Court dated so-and-so, which is marked as FF of the SOD, the respondent, that is us in our counterclaim, has been able to successfully establish the following facts. Kindly see the facts. The market price of the goods in question on April 25, 2022, my lord, that's the date of the interim order in the suit,
Correct.
was rupees 52,033, exclusive of handling and other charges per metric tons, and the respondent is entitled to get damages for what? For being unable to sell the goods at such price due to the order of injunction passed against it on the representation of the claimant that it would purchase the goods at the contractual rate of so-and-so. So, my lord, because it applied for specific performance, it got this order. Now, my lord, after having got this order, my lord, of injunction, my lord, which prevented me from selling the goods, they abandoned specific performance.
Correct.
So, my lord, it holds that I am entitled to, my lord, this, my lord, such price, etc. The contract price of the said goods being 46,433, and that the respondents could have sold the said goods even at the rate of so-and-so. It was therefore entitled to the difference being 5,600 metric tons. Consequently, it could receive an amount of 5 crores 60 lakhs being the difference in the price of the said 10,000 metric tons of goods, the total subject matter. So, my lord, this is, my lord, the finding. Then, my lord, C is port charges, my lord, that is as per the contract and as per, my lord, the, my lord, consent orders. My lord, port charges and handling charges, my lord, are to as extra. My lord, that's C and D. I'm not troubling your lordship with that, my lord, right now.
So how this 5,600 difference has been calculated? B
Per metric ton, my lord.
per metric.
My lord, because, my lord, it was 52,033
Correct.
per metric ton on 25th April.
Correct.
And contract, my lord, the contract price was 46,433.
Yes.
So, my lord, there's a difference, my lord, of, my lord, 5,600, my lord, per metric ton.
Okay. So for 52,033 minus 5. Okay.
Yes.
Yes.
That is how, my lord, it has been, my lord, calculated.
Yes.
It's, my lord, 5,600.
Yes.
That's, my lord, the difference. That's how, my lord, it has been arrived at. And 5.6 crores, my lord, because it's, my lord, 10,000 metric tons.
That's the
My lord,
difference.
yes. So, my lord, that's the difference. Now, my lord, this, my lord, damages which has been awarded, my lord, is on the principle that if somebody orders and obtains an interim order and cannot sustain it,
Entitled.
my lord, then, my lord,
Liable to
in
pay.
equity, my lord, the damage which has been caused, my lord, I am entitled to it.
Correct. Liable to pay the
Yes, it's not, my lord, a case of, my lord, a contract having been breached. This is on an equitable principle that, my lord, an injunction is always, my lord, with a undertaking that, my lord, if it is not sustained, you lose. Then, my lord, the damage that the injunction caused, my lord, is party is entitled to it. Now, my lord, kindly come to, my lord, E also at page 817. As would appear from the documents marked as JJ to the SOD, the market price of the goods on 14 June was 45,780.3. The respondent accordingly is entitled to the difference between market price of goods on 14 June and contract price being so and so. So contract price, my lord, was 46 minus, my lord, 45.7 so and so is 21.98. So, my lord, there are two heads of compensation. One is, my lord, being prevented to sell, and my lord, one is, my lord, the, my lord, normal, my lord, case where, my lord, the contract price, my lord, you don't get it because of someone else's breach,
And subsequently it is increased.
and subsequently, my lord, it has, my lord, decreased.
Sorry.
Therefore, I am entitled to that difference. So, my lord, both heads, my lord, the arbitral tribunal held in my favor. Both heads. Now, my lord, what the arbitral tribunal, however, did was only allow me 5.6 crores. It did not allow me 21.98. My lord, the argument was that, my lord, it was only 21.98 which was found,
Not the 50.
not 5.6, and 21.98 has not been granted but 5.6. With the greatest of respect, my lord, that is wrong. Now kindly come to the awarding portion. I want to show your lordships. My lord, paragraph, my lord, 59 at page 827.
Yes.
Accordingly, this tribunal rejects the claim of the claimant. However, it will be entitled to adjustment of 4.49. This is the 10%. On 30th April being 10% of total contract in question from compensation. This tribunal at the same time allows the counterclaim of the respondent and assesses the amount of compensation payable to the respondent by the claimant as under. My lord, damages 5.6, port charges 18 lakhs 12,000, handling charges 29 lakh 37, adjustment so and so of so and so.
Minus 49.
Yes.
The total amount 157.
1 crore 57, my lord, is, my lord,
Total amount.
total amount payable by the claimant after adjustment mentioned in column D is so and so.
Yes.
My lord, 21.98, my lord, has not been, my lord, awarded because I withdrew that claim. Their argument was, having found 21.98, could not have given 5.6. And in any event, 21.98 could not have been awarded because it was withdrawn. 21.98 has not been awarded. It's only 5.6. And this is what has been awarded on, my lord, 5.6, additional, my lord, port charges, additional handling charges, and, my lord, less, my lord, what was paid as, my lord, in advance.
That is to be deducted.
Deducted. So, my lord, 1.57. Now, my lord, kindly see, my lord, the basis, my lord, of, my lord, this claim, my lord, of 5.6. Kindly come to, my lord, paragraph 57. My lord, at page, my lord, 821. In fact, I should start, my lord, slightly before that, paragraph 55. My lord, at 817, where I had left off, my lord.
Yes.
My lord, after, my lord, up to A to E, as pointed out earlier, the parties have by agreement decided not to lead any oral evidence controverting the pleadings of the party, except the value of the goods on any relevant dates, and it appears from those rates filed by the parties there is no difference of rate. Therefore, there is no scope of disputing the amount claimed by the respondent once this tribunal accepts the legality of the submission of learned advocate as stated above. Mr. Chaudhary, learned counsel appearing on behalf of the claimant, however, strenuously contended that even if it is assumed for sake of argument that termination of the contract by the claimant was illegal, in that event, respondent will be entitled to no damages because the market price was all throughout higher than contract price, and as such, no loss was While making the above submission, Mr. Chaudhary treated date of breach as the date when the goods were to be delivered, but not delivered, that is 25 so and so, in 21st April 2022 under original terms of. In support of, Mr. Chaudhary relied on 57 as also following observations. Now, my lord, here your lordship recalls, my lord, that finding is now new performance.
Correct.
The mode of performance. So, my lord, the restraint was, my lord, till, my lord, 13th of June, my lord, 2022, that under the consent orders that I could not, my lord, deal. So, my lord, the price had to be, my lord, not 21st April, but, my lord, 13 June. If, my lord, Mr. Chaudhary's argument, but, my lord, kindly now come to para 56 at page 821. Similarly, provisions contained in so and so. There, para 57. There is no quarrel with the above proposition laid down by the so that ordinary is applicable. But every case has some distinguishing features when general proposition of law cannot be applied. In the present proceedings, in the opinion of this tribunal, the following conduct of the claimant should stand in the way of the claimant to avail of the benefit of general law mentioned above in the way suggested by Mr. Chaudhary. The tribunal has already held in para 26 that the effect of the two consent orders before the Honorable High Court is that the seller, by accepting the advance price over and again from the purchaser and the purchaser by again tendering which was earlier returned to it, so and so, agreed to extend the period of performance with further condition that in the process, if the value of the good falls in the market and at the same time the seller succeeds in the long run, the purchaser would be bound to compensate the seller for loss suffered by the seller due to fall in price because of the fact that by injunction order, seller was restrained from selling. Thus, the fact that added amount and secure were added would not amount in itself to superseding the original contract as they relate to payment under original and put the promisee in the same position. This tribunal further finds that original agreement was not superseded, was only sought to be honored or enforced, the manner of performance being different and consequently section. Therefore, by virtue of section 63, the original date of delivery has ceased to be the date of delivery of goods and date of delivery has been extended to 13 June till which the respondent was restrained. In this, now kindly note this, in this proceeding, it was the buyer who filed a suit for specific and was enjoying the order of injunction. The Honorable High Court maintained the order till 13 and at the same time imposed additional to protect the interest. Proceed on merit and for that reason, buyer again tendered part price. Curiously, when suit for specific performance was permanently stayed by the High Court, asking the parties to resolve dispute, the buyer in its statement of claim, instead of praying for specific performance, the contract restricted its prayer to damage by terminating the contract by its written notice through an email alleging violation of consent order. In this connection, has taken the following ground in his written notes of submissions, prayer for damages and so and so. Then, my lord, it's set out in the opinion of this tribunal, the claimant being fully conscious that was restrained from dispute, it could not before that date terminate the contract when the price of goods were falling in the market. Therefore, contention that claimant could not have expected to wait indefinitely at the mercy decision reported in so and so has no application. Then, my lord, next page, second line, which is set out from the judgment. The plaintiff cannot be allowed to abandon the case for specific performance and yet claim damages in lieu thereof as they purported to do here. If the plaintiff has to choose his cause of action, that must be done at the initial stage. He must decide once and for all whether he was to pursue his remedy by claiming specific performance, to which case he must satisfy the court till the hearing is concluded and judgment is delivered that he wanted specific. In such circumstances only, it is a matter for the court to consider so and so. If the plaintiff would choose to abandon his claim and to pursue his, then this must be done before that. If he asks for amendment by abandoning the case, he cannot be allowed to do so in the midst of the trial and to claim damages. Similarly, paragraph 25, etc. Then, my lord, page 824. And this is a principle. Clause D, my lord. This tribunal now on merit, having found that the buyer itself is guilty of non-compliance of the second consent order, it is the duty of this tribunal to restore to the seller the loss suffered by it for the order of injunction imposed against it. It is now settled law that a litigant cannot take benefit of the interim order after having lost on merit, and the benefit so taken must be restored to the other party who suffered such interim order. The following observations of the Supreme Court in the case of so-and-so. Now, my lord, these are cases, my lord, not just, my lord, one case, my lord, this case referred to another case, my lord, in para 17 of the set out portion, my lord, Mahadev Shivaram Shah, my lord. And my lord, kindly see, my lord, the portion in, my lord, bold in para 17. This court observed that while granting interim relief, the court in exercise should also adopt the procedure of calling upon the plaintiff to file a bond to the satisfaction that in the event of his failing in the suit to obtain, he would adequately compensate the defendant for loss to the order of injunction granted in. Even otherwise, the court, while exercising its equity jurisdiction in granting injunction, is also competent to grant adequate to mitigate the damages caused to the pecuniary award is consequential to the adjudication of the dispute, and the result there is incidental to the determination. The court can do so in exercise of its inherent jurisdiction in doing ex debiti of mitigating the damage suffered. Such a procedure is necessary as a check on abuse of process and adequately compensates it. Then similarly, my lord, Southern Coalfields, my lord, is also, my lord, referred to, and my lord, in paragraph 18, and it goes on.
Yes.
And my lord, para 21, your lordships will find that this relief, my lord, of 5.6 crores is based on the principle in para 21. In view of the above, the appellants are entitled to for the relief purely on equitable grounds without going into any other legal issue and appeals, and deserves to be allowed, and seniority list is quashed by so-and-so. Now, my lord, I just want to show your lordships, my lord, one case, my lord, which is, my lord, reported in 2003, 8 Supreme Court cases, 648. I would kindly take 648 para 28. At page 664. And this is the basis, my lord, for my lord, 5.6 crores.
Yes.
That no one shall suffer by an act of the court is not a rule confined to an erroneous act of the court. The act of the court embraces within its sweep all such acts to which the court may form an opinion in any legal proceedings, and the court, now kindly mark this, court would not have so acted had it been correctly apprised of the facts and law. The factor attracting applicability of restitution is not the act of the court being wrongful or a mistake or error committed by the court. The test is whether on account of an act of the party persuading the court to pass an order held at the end as not sustainable has resulted in one party gaining an advantage which it not have otherwise earned, or the other party has suffered an impoverishment which it would not have suffered but for the order of the court and the act of such party. The quantum of restitution, depending on the facts and circumstances of given case, may take into consideration not only what the party excluded would have made, but also what the party under obligation has or might reasonably have made. There is nothing wrong in the parties demanding being placed in the same position in which they would have been had the court not intervened by its interim order, when at the end of the proceedings the court pronounces a judicial verdict which does not match with and countenance its own interim verdict. Whether called upon to adjudicate, the court would act in conjunction with what is real and substantial justice. The injury, if any, caused by the act of the court would be undone, and the gain which they would have earned, unless it was interdicted by the order of the court, would be restored to or conferred on the party by suitably commanding the party liable. Any opinion to the contrary would lead to unjust if not disastrous consequences. Litigation may turn into a fruitful industry. Though litigation is not gambling, yet there is an element of chance in every litigation. Unscrupulous litigants may feel encouraged to approach the courts, persuading the court to pass interrogatory favorable to them by making out a prima facie case when the issues are yet to be heard and determined, and if the concept of restitution is excluded from application to interim order, then the litigant would stand to gain by swallowing the benefits yielding out of the interim order, even though the battle has been lost at the end. This cannot be countenanced. We are therefore of the successful party finally entitled to relief accessible in terms of money at the end of is entitled to be compensated by award of interest at a suitable reasonable for which interim order withholding relief of money had remained. So, my lord, this is, my lord, very, my lord, simple basis on which, my lord, the award has been made. The award has found that, my lord, they, my lord, refused to open a letter of credit, my lord, in terms of, my lord, the contract and, my lord, the consent order of 20th of May.
Correct.
So, my lord, they were in breach. They, my lord, had obtained an interim order on the basis that they wanted specific performance of the agreement. They voluntarily, my lord, give that up. They said, no, no, now you please give back the letter of credit or it stood stands and give back the guarantee which we had given to compensate you for it. Now, my lord, I could have, my lord, if there was no, my lord, injunction, and an injunction could only be passed if there was a relief, my lord, specific relief, my lord, sought for. My lord, I could have sold at that price and, my lord, made a gain of, my lord, 5,600, my lord, per metric ton. That was denied to me on 25th April. And that is, my lord, what has been granted.
Yes.
And, my lord, it was, my lord, on the basis of specific performance being claimed that till 13 June, my lord, orders of injunction were continued. That I'll do nothing, my lord, till, my lord, 13th of June.
Because of the interim order.
Correct. And because they told the court that I want specific performance, I'm ready and willing to pay. And this is the letter of credit, how it will be paid. And I will only take delivery after making full payment.
Yes.
And this is, my lord, what, my lord, has been, my lord, awarded. And, my lord, this story of, my lord, 21.98 lakhs, my lord, having been awarded in spite of having been given up, my lord, is not correct at all. I've shown your lordship, my lord, the, my lord, table. My lord, that is, my lord, not, my lord, the basis of this at all. Now, my lord, there are just two cases, my lord, which I need to, my lord, cite. Yes, my lord, the scope of inquiry, as your lordship knows, my lord, in, my lord, section 34, my lord, is, my lord, very, my lord, limited. Now, the two cases, my lord, which I wish to cite, my lord, first is again, my lord, Sangyong's case. My lord, kindly take, my lord, where is it? 2019, my lord, 15 Supreme Court cases. My lord, 131. I'd given a copy, my lord.
Para 58 and para 40.
Yes, my lord.
You are relied upon.
Yes.
58 to 65.
Yes, my lord. So, my lord, your lordships will find, my lord, first is, my lord, paragraph
40.
I keep my physical copy, I think I marked it there. Paragraph 40, my lord.
Yes, 40.
My lord, is, my lord, that, my lord, if the view of the arbitral tribunal is a possible view, my lord, that itself, my lord, is, my lord, good enough. If it is implausible,
no.
Then, my lord, it, my lord, and, my lord, paragraph, my lord, 58, my lord, onwards. My lord, is, my lord, what, my lord, comes within, my lord, the scope of
34 2A.
Yes. This I have, my lord, already cited.
Yes.
My lord, the other judgment, my lord, on plausible view. Which one is it? Oh, Concon, yes. Now, my lord, kindly take, my lord, The Konkan case, my lord, which is, my lord, 2023, 9 SCC, page 85, my lord. Is it in my notes? Which para?
Yes.
My lord, kindly come to, my lord, paragraph 29, my lord. My lord, having considered the matter in detail, we are of the opinion that division bench of the High Court committee in setting aside concurrent and saying the award of the arbitral and decision of under section cannot be termed as perverse or patently illegal as concluded. The decision of the arbitral tribunal is a plausible view, and the single judge refrained from interfering with it under 34. The division, so my lord, as long as it's a plausible view, my lord, I don't have to establish anything more. And my lord, with the greatest of respect, there is nothing to show, my lord, that there is a patent illegality in this case or, my lord, perversity. And my lord, this is the last case. Yes, my lord, one other case, my lord, which is a recent one, my lord, that's, my lord, 20. My lord, 2024, two Supreme Court cases. I've written it down here. Where is it? My lord, paragraph 26, my lord, kindly take. My lord, para 26 at 627. The prevailing view about the standard of scrutiny, not judicial review of an award, by persons of the disputant's choice, being that of their decisions to stand and not interfered with, save a small area where it is established that such a view is premised on patent illegality, or their interpretation of facts or terms perverse as to qualify for it, courts have to necessarily choose the path of least interference except when absolutely necessary. So, my lord, the standard of scrutiny is not a judicial review. My lord, it has to fall within, my lord, the four corners of 34. Then, my lord, kindly, by training, inclination and experience, judges tend to adopt a corrective lens. My lord, we take advantage of that. My lord, in 34s, usually commended for appellate review. However, the lens is unavailable when exercising jurisdiction under section 34 of the Act. Courts cannot, through process of primary contract interpretation, thus create pathways to the kind of review which is forbidden under section 34. So viewed, the division bench's approach of appellate review, twice removed, so to say, under 37, and conclusion drawn by it resulted in displacing the majority view of the tribunal and in many cases the unanimous view of other tribunal and substitution of another view. As long as the view adopted by the majority was plausible, and this court finds no reason to hold otherwise, because conceitedly the work was completed and so, comprising both soil, such a substitution for, and then, my lord, the cases, my lord, are referred to. My lord, this is so, my lord, what I wanted to, my lord, we as lawyers also, my lord, try to persuade the court to undertake a judicial review, my lord, under 34. But that is not, my lord, the scope at all. My lord, now the two lead cases associated as interpreted by Sangyong, my lord, is, my lord, what needs to be looked at. And my lord, it says if it's a plausible view.
Then on.
Yes. And my lord, I had cited the UCP, my lord, on the last occasion, my lord, which your lordship had I hope your lordship has that, my lord, the commercial.
Yes, UCPC, sir.
Yes, my lord, I had, my lord, drawn your lordship's attention to Article 14, my lord.
Yes, 14B.
Yes.
14B.
So this is what it was, my lord, here. It says 3 days. So therefore, my lord, for sight, it's otherwise 5 days. So when, my lord, the order says 3 days, my lord, it's usance and tenor. But, my lord, payable, my lord, at sight. Because, my lord, it also provides for, my lord, delivery upon payment.
Correct.
And, my lord, both contempt petitions, my lord, it's not there, it's gone. My lord, after, my lord, the arbitral award, my lord, the last contempt petition which was there has also, my lord, of 20th May has been disposed of. Yes. So, my lord, this is all, my lord, which is before, my lord, your lordships. My lord, whether consent order complied with or not was very much the subject matter, my lord, of, my lord, the case made out by the claimant and, my lord, decided, my lord, by, my lord, the arbitral tribunal. Arbitral tribunal has held that they were in breach, my lord, of, my lord, the agreement.
Because of the obtaining the interim order, they are not come
And not
forward.
just that, my lord, they failed to open a letter of credit.
That's why they
Yes.
have not. They are
My
not
lord, if they had opened it, my lord, that was in any event they were in breach. Therefore, my lord, not even damages. Let alone, my lord, specific performance. So, my lord, my lord, I thought I'd take longer, but my lord, I've finished. So, my lord, I'm
Thank you.
obliged to you.
My lord, Mr. Chinoy would, because he has requested the Honorable Court to give him a time to give a reply.
When he
and
will be available?
Tomorrow it's at 12 o'clock.
Tomorrow it was already fixed, but he has requested for a time 3 weeks after, if it could be.
3 weeks, then I will. This court will. I don't know. This court will remember all the things. Tomorrow he will not be available.
He's not there tomorrow, my lord. That is why he has requested the Honorable Court if a time could be given 3 weeks after.
3 weeks is difficult.
Especially एक और ना होता कहता है
No, particularly to have an- I don't know if it's assigned. If it's assigned.
Because also
My lord, this is an assigned
it's
matter.
an assigned matter, and if it could be marked as parted also, then
No, not I will take. But
there is no
whatever
need
the
also.
argument has been, then this court again it has to be.
Yes, my lord, it have to be.
Again, it has to go on.
But yes, if your lordship so if it's so commensurate to your lordship, if the matter is kept tomorrow, because any which way it is due to appear tomorrow, and we'll take further instruction also
So
if
that
it
they
is
come back
convenient.
before 3 weeks. my
Yes,
lord.
before 3 weeks, if it's convenient, then I'll inform the court accordingly.
Tomorrow, what will be the
Yes.
convenient date?
If it is kept as
Before
to be
3
mentioned, then because it was otherwise fixed at 3 o'clock tomorrow.
12 o'clock.
12 o'clock
12 o'clock.
tomorrow.
Tomorrow
Yes.
it's 12 o'clock.
So at 10:30, if the matter is kept as to be mentioned, then I'll indicate to
It
your
will be in the
lordship.
list. It will be in the list. You mention
My
it.
lord, let it be marked at 12 as it was directed.
That is as
And at 12 o'clock we
you
can
mention-
come and take.
You take
Very
the
well.
instruction.
I'll take instructions
Before
and get
3
back.
weeks it is possible, then I will fix accordingly as per diary.
My lord, I'll do that.
So appearing for the petitioner, so appearing for the respondent. Counsel for the respondent has concluded his argument. The matter is already fixed tomorrow at 12. Let the matter appear tomorrow at 12.
Okay, so 12 hours.
Come tomorrow, please.
Yes, your lordship, I'll get back.
Take this. Yes, next.
Number 20.
Lordship. Your Lordship, I'm appearing for the plaintiff, Your Lordship. Your Lordship, on the last occasion, interim order was confirmed by an order dated 28 July, which I'm handing over to you, to Your Lordship. Your Lordship, directions may be given for discovery and inspection. Of the...
Yes, your lordship.
Yes, Your Lordship.
It was filed on 29th September 2022.
Huh?
Lordship, I'm appearing for defendant number 1. We have already filed a written statement.
Where is the written statement? No written statement is on record. Hey, written statement hai वहाँ में? You are appearing for?
Defendant number 1.
What about the 2? Yes, 2 had appeared.
Yes,
2
sir.
has filed the written statement.
Your Lordship, I have no knowledge. I'll
Written
come.
statement. You have received the written statement of the defendant number 1?
No, Your Lordship. I have not in my brief.
When
Your
you
Lordship.
filed?
Your Lordship, it was filed in the year 2022, 29th September.
It's not in the record.
Your Lordship, it's showing in the CIS also.
What CIS? What says the CIS? Record and order. And what about the defendant number 2 and entered appearance?
They are not. No, no, Your Lordship. Till date, they haven't.
Where is the affidavit service? Where is the report? The writ of summons was served upon the defendant number 2.
Your Lordship, that was filed.
No, there is no report also. So appearing for the plaintiff. So appearing for the defendant number 1.
Defendant number 1.
None appears on behalf of the defendant number 2. Counsel for the defendant number 1 submit that. The defendant number 1 has filed the written statement on
29th September 2022.
On 29th of September 2022. Have you received the copy?
No, Your Lordship.
But the counsel for the plaintiff submit that she has not received the copy of the written statement. This court also find that no written statement is on record. No written statement filed by the defendant number 1 is on record. Full stop. In view of the above, the department is directed to place the written statement, if any, filed by the defendant number 2 in the record of CS. केस में नंबर भी नहीं चढ़ता, रिकॉर्ड में नंबर भी नहीं डलता. CS com number, item number
20.
CS 283. 283, 285. 283 of 2024, old CS number 133 of 2021. The plaintiff is also directed to obtain report from to submit the report with regard to service of writ of summons upon the defendant number 2 on the next date fixed. List the matter on 25th of November 2024.
Grateful, Your Lordship.
Next.
Your Lordship, I am appearing for the plaintiff in this matter. Your Lordship, once the suit was filed in 2021, the defendant number 1 to 4 have not entered appearance to date. And
Service and writ of summons was served.
yes, Your Lordship, and I have the report.
Give the report.
Lord, I appear on behalf of the defendant numbers 2 to 4, my lord. Kindly permit me to appear virtually today, my lord. My lord, I'll tell your lordship the very brief facts of this case, my lord. There was a license agreement which was entered into between the plaintiff and the defendant numbers 2 and 4. My lord, alleging breach of that license agreement, my lord, the plaintiffs filed this suit for injunction and damages. My lord, thereafter, my lord, the matter was heard first without affidavits. My lord, my learned friends were not successful in obtaining an interim order of injunction. Lord, thereafter, my lord, when the matter was eventually heard on affidavits, my lord, the injunction has been granted. My lord, that is the stage of the suit at this juncture. My lord, your lordship will not find any application pending. My lord, only steps have to be taken in the suit. My lord, as my learned friend has already pointed out to your lordship, my lord, the writ of summons was served on us. My lord, we've not filed the written statement. My lord, I can confirm that. My lord, we've not filed any written statement. My lord, although it has been served on us.
No, you have not entered appearance till 12th of August 2024.
Yes, my lord, we've not entered appearance. My lord, we were contesting the injunction.
Report, service report.
Your Lordship, if I may produce that.
When the Writ of summons was served.
Your Lordship, it was served in 2021, Lordship. If I may
Huh?
get 2021, if I may get back to your Lordship with the date, if your Lordship gives us a short time.
Yes. How many defendants are there?
My lord, the
There are
total
four.
of 4 defendants. My lord, I represent the defendant numbers 2 to 4. My lord, the principal defendant number 1 is perhaps not appearing today.
One is not appearing.
No, my lord. My lord, because I am for 2 to 4, my lord.
So appearing for the plaintiff, so appearing for the defendant number 2 to 4 through virtual mode. Full stop. Counsel for the plaintiff has handed over the report dated, a report submitted by the Deputy Registrar Legal dated 12th August 2024, wherein it reveals that none of defendant number 1 to 4 have not entered appearance till 12th of August 2024. Full stop. There is no record. Counsel for the plaintiff press for time to obtain report from the department to ascertain whether the writ of summons was served upon the defendants or not. In view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 26th of November 2020.
My lord, only one indulgence, my lord. Very humbly, my lord. My lord, the wakalatnama may be permitted to be put in. My lord, of course, my lord, this, yes.
Let they obtain report first when
My
you...
lords. My lords, as your lordship. I'm
Grateful,
grateful.
your Lordship. Grateful.
Next.
Wait, please, Malak.
Yes. Lordship, item number 22, I am for the petitioner. And Lordship, I am praying for 1 week adjournment because there will be a change in advocate on record. So we will need time to take instruction, Lordship. So, and we will file new wakalatnama also. Kindly fix the matter after a week.
In fact, we are very lucky that this matter is finally called on after a long time.
No,
In
Lordship,
fact,
kindly,
I
it's
tell
my
you, Lordship, we have a section 8, that is GA2. Well, that's to refer the matter to arbitration because it is our case that we have an arbitration agreement between
When you
the
filed
parties.
the Section 8 application?
Well, right at the stage when the injunction application was filed, immediately. In fact, although we have filed subsequently, we have filed a written statement without prejudice to our rights because although Section 8 was filed prior to, of course, I have to file it prior to the written statement. So,
the problem
I am
is
ready,
that,
to argue my Section 8, but
there is a change in advocate. Kindly, my lord, fix the matter in after a week.
Is Section 8 application there? Why in commercial division?
well, it's a commercial. I'll tell you, Lordships, we were investors in East Bengal Football Club. And disputes comes in it's out of that investment agreement between the parties. That's the reason for absence. But it's for them to, we have also taken that point, but it's up to them to satisfy that.
So you filed the affidavit. Affidavit is completed.
Yes, so I think pleadings are completed because opposition and reply has been filed.
You are appearing for all defendants.
No, I am for respondent number 1.
I appear for respondent number 2.
In fact, why it's also not maintainable because respondent number 2 was under liquidation under the provisions of the Insolvency and Bankruptcy Code. So the suit also against them, of course, I'm not responding.
Yes, take note of it.
Yes, Lordship.
Because 33 days.
Take note of it.
Your Lordship's judgment also one of the judgments covered that.
Record. What about the other defendants served?
No, Lordship, I need to take time, Lordship, for the instruction, kindly, Lordship.
Suffering for the defendant number 1 and suffering for the defendant number 2. Full stop. Counsel for the defendant number 1 submit that. Defendant number 1 has filed an application being GA1 of 2021 under Section 8 of the Arbitration and Conciliation Act for referring the matter to the arbitrator. For the arbitration. Full stop. Counsel for the plaintiff prays for time to ascertain whether the writ of summons was served upon all the defendants or not. Accordingly, the case adjourned. Let the matter appear on 25th of November 2024.
Grateful, Lordship.
Lordship is keeping on 15th. 20. Can I prefer 25th? Some difficulty. I was praying for 26th. If your Lordships can.
26.
26. I'm so grateful. So deeply obliged.
Next.
Grateful, Lordship.
Why after 2021 the matter is not listed? Why? Going on. Yes,
Your
Mr.
Lordship,
Dutt.
I'm appearing on behalf of the plaintiff, Your Lordship.
Item 23.
Yes, Your Lordship.
Yes.
The Lordship kindly keeps it in the month of January because we are in the process of taking out an application under Order 13A. We are already enjoying an interim order for injunction on the bank guarantee, which has been extended till the disposal. Now we are in the process of taking out an application under Order 13A of the Commercial Code Act. Kindly, the Lordship kindly keeps it in January. In the meantime, we'll take out the application and move back.
Why so late? January? Now we are in November. In between, December is also there.
Very well. Your Lordship keeps it in December. I'll move the application by that time.
Plaintiff. None appears on behalf of the defendant. As per the submission made by the counsel for the plaintiff, the case adjourned. Let the matter appear in the combined monthly list of December 2024. Next.
Grateful, Your Lordship.
In serial number 24, we are for the defendant.
Huh?
We are for defendant number 1.
Who is for the plaintiff?
My lord, the matter is being taken up after September of 2022.
So?
Certain directions were passed upon the plaintiff to make certain paper publications. Now, after that, my lord, the matter has not been heard.
How many defendants? 8.
There are 11, my lord.
None appears on behalf of the plaintiff. So, instance appearing for the defendant number
1.
Full stop. For the interest of justice, the case adjourned. Let the matter appear on 19th of November 2024. It is made clear that on the date fixed, if none appears, appropriate order will be passed. None appears on behalf of the plaintiff, appropriate order will be passed.
Grateful, my lord.
25.
Think.
25.
Everybody is there.